My lord, all these matters now are pending before the Honorable Apex Court. Your Lordship knows that this
Yes, whether
Honorable Court.
OPDI Act will be attracted in this kind of situation or not. That's what you want to say.
In this case, my lord, with respect to my senior, my lord, OPID counsel is not there, my lord. They have to serve copy on the OPID counsel, Mr. Bhuiya, my lord.
Mr. Bhuiya,
My lord.
you have not supplied copy to Mr. Bhuiya?
No,
OPID
my
counsel?
lord,
We have supplied
we have
copy.
supplied copy.
Then let us wait. I'll pass it over. Let us wait. Let him come. The moment he comes, then I'll just call you.
Yes,
All right. All right, my
Let us
lord.
see. Let Mr. Bhuiya come. Okay.
Item 2.
Pass over.
Item 3.
And here, initially, FIR was lodged. Your Lordship may kindly turn to Annexure 2 at page 20.
Page
FIR
20.
was- Yes.
Yes.
FIR was lodged under section 3, 4, 5, 6, and 7 of the Immoral Trafficking Act.
Hmm.
Admittedly, as per the prosecution case, the present petitioners are the customers who had gone to the spa center.
Hmm.
In this FIR, I was arrested and was granted bail.
I think you argued this matter earlier.
Yes, Your Lordship.
Where is that order?
That order is
Yes.
dated.
Yes, last order read.
Yes. Last order is, Your Lordship will kindly see, order dated 3/1/24. Your Lordship has already formulated the point on which Your Lordship wants to hear.
Yes, 370. They are customers.
My lord. My lord, if one or more customers are there, my lord, then my lord, that section, my lord, 370
Let us see.
may be attacked, my lord. That
No,
are,
but
one of the COAC is also filed for it to his case, my lord, 3384/2023. This honorable dispose upon 1/9/2023, direct him to approach before the court below, my lord. Since the other offense added in this case, my lord. COAC is, my lord.
where is that order?
Manager.
He is the manager.
Manager.
He is customer.
Quoted with
Yeah,
the
370. Let us see. You say that
Your Lordship,
370. Let us see.
Your Lordship may kindly see. Whosoever for the purpose.
1 minute. 1 minute. I'll just.
Trafficking of persons. 373 subsection 3.
370.
370 subsection 3.
3. Huh?
Where
enough.
the offense, I'm sorry, madam.
Mhm.
Your Lordship has got it.
Yes, I got it.
Where the offense involves trafficking of more than one person, it shall be punishable with rigorous imprisonment for a term. Trafficking. The
Trafficking
word
is.
trafficking.
But come to 370A.
Yes.
Exploitation.
Exploitation of a trafficked person. Whosoever knowingly or having reason to believe that a minor is being trafficked and engages such minor for sexual exploitation in any manner. Engagement. Manner, I have not engaged him.
What about the girls? Those who have were recovered, they were minors or
Some are minors, my lord. Some of the girls are minors. And
such minor for sexual exploitation in any manner.
But my
Shall
lord,
be punished
as a
with
customer, how will I know it?
punishment for term which shall not be less than 5 years, but which may extend to 7 years.
And 3 is very clear where the offense involves the trafficking of more than one person.
My lord, what?
No, that's right. But whether it is the customers, those who were there while the raiding has taken place, they are not the people those who have trafficked. The manager of the spa has done it, and these people who are taking. You can make out a case for 370A because exploitation of a trafficked person. There are two requirements. One is a person who is involved in the trafficking and he is exploiting.
They are exploiting.
ठीक है, but it is both traffic and exploitation.
My lord.
But in this case, at least you can very well say that they were exploiting, but they were not trafficking.
My lord. They are-
So whether for mere exploitation
My lord.
and the qualifying expressions are
My lord.
knowingly or having reason to believe that they are.
My
See,
lord.
customers may not be knowing it. They will not ask Aadhaar card and all.
Coming
See, these
there, my lord,
youngsters-
for that purpose, they are very well.
Just see the
Our
youngsters.
party, my lord.
But how can it be said that I was aware that? and you
What
told
way
me
we
that?
can, because see, these people, just see the age and all.
My lord.
Just see. 42 years. Yeah,
than 42.
you people are businessmen.
Businessmen, they had gone to this park. And they have enjoyed. There is no bar in that. I don't dispute on that.
That
fact.
out, my lord, we are at the cognizant stage, my lord. You can raise at this point before trial from the chat, my lord.
Trial on these two sections.
Only because these sections are added, my lord.
You develop your argument in 370 capital A. 370 is ruled out against them.
My lord.
Develop your argument on 370 capital A. Capital A, just see.
My lord.
Develop your argument. You may have a case on that. 370 exploitation. 370 capital A. Just
Madam.
read. Whoever
Whoever
knowingly or
or
having reason to believe
that a minor has been
traffic.
engaged such minor of a sexual expression in any manner.
So see,
Actually,
My lord.
traffic, the customers may be knowing they are traffic, no doubt about. They have a knowledge
Madam.
that these people are not, they are traffic. So this is there.
Madam.
Engage such minor
Madam.
for sexual exploitation,
Manager, my lord, that
but they have not engaged.
You have not,
Manager might be there, my lord.
manager is there.
The minors are engaged. For
Yeah, who has engaged?
person
Ah,
who was
that-
engaged this
So I
Engages.
think
Engages.
you need to deliberate on this issue.
My lord, my lord.
I will put it on second.
Second, my lord.
Second, you deliberate and get the
My lord,
judgment.
my lord.
This is a case where
Madam.
we can,
Madam.
370
My
is
lord,
very
that part, my lord.
interesting,
Madam.
engage
Exactly.
knowledge and all these things.
If that section will go, my lord, then other sections are applicable to.
The other section
Madam.
he is not making any.
Madam.
He says 370 and
Madam.
370A
My lord.
is not attracted because I am simply a customer. I had no knowledge. I went and paid the money and
My lord.
engaged myself.
All the statements say that the manager had brought them. And not a single statement.
What about the manager? Has he filed
He
the?
has filed case, my lord. This honorable directed the land court. He has to surrender before the court below. That is the direction.
But he doesn't have a case.
Since the offense added, my lord, subsequently, for that reason,
He doesn't have a case.
my lord.
Immoral Trafficking Act, they are they
Madam,
have to
madam.
face the trial.
My lord, only
Only-
my lord. 70.
370 doesn't, is not made out. 370 is not made out, but 370
A.
capital A may be because of that exploitation.
Madam.
Just check it up.
What do, my lord, your lordship cannot, somebody.
There are qualifying expressions.
Yes, and both the words cannot be bifurcated from each other.
That is what he will argue.
Yes,
My lord.
he cannot separate, it is not a case where the chaff has to be separated from the grain. Here, the grain and the chaff has to be there at the time. Like in criminal murder cases, we have to differentiate between the chaff and the grain. Here, the
Who are
chaff-
you? You are the grain or chaff?
My lord, I am the grain, who is the.
Paying money and doing all these things at the age of 42.
That.
I was thinking that you are a student, youngsters and all,
It's very disputed question, my lord. We cannot answer it.
Use very knowingly.
knowingly that.
Knowingly. That
But,
is interest-
but we have to read as a whole.
Cannot escape from that one.
We have to read, we have to read.
So therefore you develop that. argument. Let us see and second,
Say that- Oh,
second, further argument second.
My lord.
Okay. Item?
May I please, your lords?
Cut out of
Okay.
some judgments.
Madam.
Okay.
Case counter case. We have lodged an affair against them, that is annexure 2. And they have lodged affair annexure 1, my lord.
Hmm.
I have filed a petition before the court below to heard this matter together, my lord. My application was rejected under annexure 4, my lord, order dated 7/8/23 at page 23.
23, yeah. What the trial court says?
Trial court says heard both the side at length peruse the FIR charge sheet as well as other connected documents of both the records, makes it appears that both the cases was registered on the same day, that is 13/3/2022, but at different time and relates to the incident occurred on 12/3/2022, but at two different times. Also, the offense alleged, and except for a few individual, the person involved therein are different
So
in
then
both the
two
cases.
different incident,
No, same incident, my lord. There is a case and counter. Thereafter, he has stated. Moreover, in law is well settled that case is said to be the counter and another case when both the originated from a single incident happening
Hmm.
at one particular area at one time, which can be in the opinion of a reasonable
What are
man.
the offenses?
Offenses, my lord. We have lodged an FIR annexure 2 at page 15, my lord,
The offenses.
143, 147, 294, 506,
Okay, next, what is the offense?
379, 452.
The same kind of offenses.
No,
No, no,
even in the
uh,
sessions tribal offense there.
Huh?
Sessions
Sessions
tribal,
tribal.
302.
That case has been committed to the Court of Sessions, my lord.
Yes,
It's committed.
My lord.
yes, ma'am.
Then how can you tag the?
It is not coming under, my lord, the case.
Uh,
and counter, my lord. But can I say
Your lordship kindly see that is 101 against us, my lord.
But incidents are different.
No, same incident, my lord. Your
Same
lordship
incident.
kindly peruse,
the
that is at page
hard
6,
case,
your
my lord.
lordship kindly see.
Just see, let the prosecutor see.
Gangapur, Gangapur
Gangapur.
PS case number 101, my lord. Timing is 21 hours to 10 hours, my lord. But here, my lord, the Gangapur case number 102, my lord. Timing
21 hours.
21
What is the difference?
20.
Difference of time.
time is difference, my lord.
How much?
He's saying that as per my lord, 10 minutes, my lord, difference, my lord.
10 minutes.
My lord.
Yes, my lord.
Oh, that is.
And that happened, my lord. Another thing,
Hmm.
FIR laws different time, FIR laws have different
No,
time.
just see the allegations in both the.
My lord.
Incident is same or not? 10 minutes for 5 minutes. What is
Yes,
Not-
same incident.
Hmm.
Allegation out of political
Just see-
dispute.
Just see page 11. Today on 13/3/2022 at about 1:45 p.m. the complainant namely so and so. Okay? Page 11. Let us.
Yes,
My
sir.
lord.
Please, here at page. 10:45. Just see, come to page 19. Page 19.
10:45.
At 10:45 a.m. Today on 13/3/2022 at about 10:45 a.m. the complainant wants.
At 1:45 p.m.
Then that is
10:45 a.m. Reported the.
that is just 1:45.
My lord.
1:45, that is 11:45.
My lord.
Also, then there is a difference of 2-3 hours.
So far lodging the FIR is concerned, my lord. Yes. That is the lodging the FIR, my lord.
Incident
Instead, my lord,
at about 9 p.m.
my lord.
9 p.m.
Till 9 p.m. At about 9 p.m. Page
Yes.
11.
Yes.
While discussing
That
with
I-
him in front of his house towards middle, my lord. At about 9.
That let us come to 19.
That was at about
On
9 p.m.
12/13/2022 Saturday night at
9
about
p.m.
Place
Nine.
difference.
9 p.m.
That time,
Yes.
some person enter into the house and took away the mobile phone, my lord.
The-
Here, my lord, the
Out of same
different
incident.
cases, my lord. They can't treat it as the case and count case, my lord. Place is difference, my lord. Time is difference, my lord.
Place is different, time
And,
is different.
My lord, one case committed to court was and ST case will be registered, my lord. If it is case and counter case, then both the cases will be tried before the one court, one after another, my lord. Here, but it not the case and counter case, my lord.
Mhm.
Place of occurrence is difference, my lord. For that,
Look, the petitioner has filed this present petition assailing the order dated 7/8/2023, whereby his application to try both the offences analogously by one court has been rejected. Next, it is submitted that FIR number
101.
Gaganpur PS case number 101 annexure 1. annexure 1 and annexure 2 FIR number and FIR numbers also in annexure 2 are counter cases. Therefore, the trial should have been conducted analogously. However, perusal of the FIR, perusal of both the FIRs indicates that the timing of the incident is different. And
Place also.
No,
place of
timing
occurrence,
is same, my lord.
no different.
Now, your lordship kindly peruse,
Yeah,
9
that's-
PM.
Place of occurrence is also different.
Difference.
And in one case, the charge is under 302, which is
307.
uh, we-
307.
tribal by 307,
Tribal by
which is
session,
tribal
session.
by the Court of
Hey,
Sessions.
occurrence, my lord, same place. Your lordship kindly peruse.
Interpreting has already been taken place. Therefore, I find no reason to interfere in the
No,
in order. Please.
No, your lordship kindly peruse. Same occurrence, my lord. Same date, same occurrence, my lord. Your lordship kindly
That
see
is
for
what
a
the
moment,
trial
my
court
lord.
says, he has
Right.
to point
Your
out.
lordship kindly peruse the FIR I have given, my lord.
The
That
level of assistance is very bad. I tell you, these cases should not take seconds, 1 second. You are searching where is this thing.
no, that is there in page 19, my lord.
How will I finish the board of 65, 70 matters if the level of assistance is so bad?
No, your lordship kindly same place of occurrence is same, my lord. Out of political dispute, both cases arises, my
So I
lord.
have taken a view, maybe wrong. What to do? I have taken a view. According to me, the place of occurrence is different
Difference.
and
How?
one case is tribal by the sessions. You will lose one forum also. You will lose one forum.
If it is a case and counter case, then they go to 1 court, my lord. It is
Hey,
not counter case, my lord.
Two different.
101, 102. Both are
Similar
laws
law.
FIR against each other. And the
Consider
place of
counter-
occurrence is same.
Accused are-
Timing is same, my lord.
Accused persons are also different.
No. Same persons,
If
my
the
lord.
document is Same, my lord, then.
Same
Incident not
Maya.
same, my
Some
lord.
accused, just see the
Difference
names.
incident, my lord.
No, your lordship kindly see.
Incident not one, my lord. Incident two different to incident.
And
No,
accused
accused
persons
person against
Let's
each other, my lord, they have lost this FIR, my lord.
ଦେବେନି କଣ ଆଉ ସେ ଗଣ୍ଡଗୋଳ ଥିଲେ ଅଲଗା
ନାଇଁ,
ଅଲଗା ସେମାନେ
same
ଏକା ଦିନକରେ
କହୁଛନ୍ତି
ହେଇଛି
ତ।
ଘଟଣାଟା କିନ୍ତୁ ଅଲଗା ଅଲଗା ଜାଗାରେ ହେଇଛି
No, same timing is same, place of occurrence is same, my lord.
ଟାଇମିଂ ଟା ହେଲେ ହେଇଛି
Your lordship, I will peruse, my lord. I am that FIR, my lord. Your lordship kindly see. ନବୀନ କୁମାର ପଣ୍ଡା ଆଜି ତା 13/3/2022 ଏଇ ରିପୋର୍ଟ ଦେଉଛି ଭଞ୍ଜ ସ୍ୱାଇଁ ମାତା ମମତା ସଭାପତି ହୋଇଥିଲେ ସେ ମତେ ନାଇଁ ଆକ୍ୟୁଜ ପର୍ସନ ଡିଫରେଣ୍ଟ ହେବେନି କେସ୍ କାଉଣ୍ଟର କେସ୍ ରେ
ଅଲଗା ଅଲଗା କେସ୍ କିନ୍ତୁ ହବ
different, sir. I have seen
No,
it.
no.
It's there in front of me.
accused person are different, my lord. In case other accused person counter obviously ଆଜ୍ଞା କେସ୍ କାଉଣ୍ଟର କେସ୍ ହେଲେ ଇଏ ତା ନାଁରେ ଦବ ସିଏ ତା ନାଁରେ
ତା
ଦବ
ବାଦେ ଅଲଗା
Not the whole
ଅଧିକା
accused persons.
ଯୋଉଟା present ତାପରେ ଅଧିକା ଲୋକ
There are added accused persons.
ଅଧିକା
yes, my lord.
Other accused persons also.
other accusations
Yes, my lord.
Then
ନାଇଁ other accused person is
so
concerned, my lord.
I have passed an order that I think. Yeah. You try in another better case. Anyway, next.
item 5
Not press. This is the best submission, possibly. Yes,
item 6
yes.
Due to non-appearance, NBW was issued.
How much will you pay? When are you on bail?
But
Bail?
this is a,
during course of investigation they are on bail, my lord.
yes,
They were on bail. Subsequently charge sheet submitted and they issue summon. No.
ठीक।
That's you are.
ठीक है NBW order dated कहते 11/7/22
आज्ञा।
NBW 313
stage is
recording of
300.
statement 313
Yes.
thereafter you operated.
That's a communication gap that you will also.
How much will you pay for communication? 1,000. 1,000.
Those are your lordship's prerogative.
No, not prerogative.
It's
I am
better.
asking because it
It
will
is
go to you
better.
only.
Only bar council, High Court Bar Association.
High Court Bar Association. Go to High Court Bar Association.
Jao.
I have to ask you only.
That's the only way to enrich our assessors.
For that,
Yes. When will you, before 20th you appear? 20th of this month. You appear before 20th. Yes,
item 7.
May it please your lordship.
yes.
My lord, the petitioner challenges the order dated 11/9/2023 as per Annexure 7
Mhm.
passed by the Learned Special Judge Vigilance,
Hmm.
wherein the Learned Special Judge has been pleased to reject my petition for supply of a copy of the CCTV footage what has been recorded during investigation.
What is the reasoning?
Reason shown
Hmm.
that whether that CCTV footage what has been recorded and produced before the court, ultimately whether prosecution will rely upon it or not known at this stage. So at this stage, the court below feels it proper that not to give a copy of it. With respect, your lordship, it is not sustainable. Your lordship may kindly permit me to place the facts within 2 minutes,
Okay.
my lord. As per Annexure 1, your lordship, one Sibo Prasad,
You find the difference in the CCTV footage.
my lord. That is exactly my point.
You
Your Lord.
you find your defense there.
And defense cannot be
Prosecution,
taken.
perhaps you are saying that prosecution may rely or may not rely.
Doesn't
But
matter.
If I find defense in that document, it is under your position, you give it to me. That's what.
Exactly, your lordship.
Exactly.
Difference cannot be taken in piecemeal. I have to taken it once for all, not on ad hoc basis. The case, your lordship, and nothing to hide, your lordship. Everything is to be placed before the court. The prosecution cannot keep anything secret, and this is not the way for the criminal prosecution to go on. Your lordship may kindly see one Sibo. I am only placing the fact only within 2 minutes.
Yes.
Man. One Sibo Prasad Jena lodged an FIR against me. I was working as IIC Gop PS under Puri. Sibo Prasad Jena said his brother Akshay Jena has earlier lodged an FIR before IIC Gop PS, which IIC Gop PS didn't register, demanding rupees 5,000. And after repeated persuasion, when he didn't register, then Sibo Prasad Jena offered 3,000 to him. And accordingly, FIR has been lodged that on this day, 27/9/2019, I am going to offer the payment of 3,000 what has been demanded. This is FIR, your lordship.
Hmm.
Now, accordingly, after this FIR, a detection report was prepared, investigation carried on, charge sheet submitted. In the
It's not a trap case.
No, not a trap means, your lordship, the money has been recovered from the table, not from my possession. Hand was taken, nothing, caller
That's your
didn't check.
defense.
My lord. Now, Sibo Prasad Jena examined during investigation under 161 CRPC statement recorded. Sibo Prasad Jena said, my brother Akshay Jena has given the money.
161 Sibo Prasad Jana said,
161
my
CRPC
brother had
statement.
gone there.
My brother has given it. Then his brother's 161 CRPC statement was recorded. He said Sibo Prasad Jana has given it. Overhearing witness Biswajit Behra was there. Biswajit Behra said Sibo Prasad Jana's brother Akshay Jana has given it to Sibo Prasad Jana to give it. Your Lordship may kindly
What is
see.
the stage of trial?
That is before framing of charge I have come, Your Lordship. I require this document in order to plead discharge, Your Lordship. My Lord may kindly see. On this basis, detection report annexed to the presence of Akshay.
She showed me the reasoning.
My Lord.
Reasoning it, having heard from both the learned counsel and perused the record, it appears in the case record that after completion of the investigation, the prosecution has submitted the charge sheet against the accused, and now the case is posted for consideration of charge. And in the meantime, the defense counsel filed the opposition in order to supply the extracted copy of footage being recorded and should be installed in the chamber of violation. Also, it is well settled that the defense has every right to get the copy of all the evidence of the considering that are being relied on by the prosecution. It is mandatory to supply the documents relied on by the prosecution to the accused to give him an opportunity of correct time. But the case record reveals that the case be posted for consideration of charges. As such, the trial of the case is not yet commenced. Therefore, it is not known prosecution was for trial. Hence, at this stage, it is not possible to supply the structure. Yes. What do you say?
Lordship may
Hmm?
Lordship may allow. It's all fair with all fairness. So Lordship, the prosecution has laid the same document, extract of that document in the charge sheet. So he's entitled for that.
Right on.
The extract,
the
my
petitioner-
one thing is the extract of that CCTV footage may be
Okay.
later.
That is
the petitioner has challenged the order dated 11/9/2023 passed by the first additional sessions judge cum special judge Vigilance Bhubaneswar in TR case number 9 of 2023, whereby his application
Under Annexure 6.
application under any application for direction seeking supply of CCTV footage on CCTV footage of the place of occurrence dated 27/5/2019 has been turned down by the trial court. The trial court in the impugn order opined that the petitioner being an accused is entitled for all the documents that are those are relied upon by the prosecution in the charge sheet. In the instant case, charge has not yet been filed. Therefore, the trial court declined the prayer of the petitioner accused, stating that the CCTV footage cannot be supplied to the petitioner for creating probable defense in his favor. Heard Mr. So for the opposite party. He fairly submits that the extract of CCTV footage has been relied upon by the prosecution in the prosecution and
Charge sheet.
prosecution which is apparent in from the perusal of the charge sheet. So therefore, full stop. Therefore, the accused in any case is entitled to all the documents those are relied upon by the prosecution in the charge sheet. Since extract of CCTV footage being part of the charge sheet, the petitioner is in any case entitled for the claim. Next follow. Therefore, for the foregoing reasons, the impugn order is liable to be set aside, and accordingly, the order dated 11/9/2023 passed by a special judge Bhubaneswar, special judge vigilance Bhubaneswar in TR case number 9 of 2023 is set aside, and the set aside, and the prosecution is directed to supply the extract of CCTV footage of the GO PS on the date of incident, that is on 27/5/2019.
At the cost of the petition. At the cost of the petition.
At the
I have written at my cost. I have written it.
at the cost of the accused as at the cost of accused. Actually, you have
Actually, free of cost, my lord. Yes, your
don't
lordship.
write that.
My lord. Because I
You may say whatever.
ନାଇଁ, ମୁଁ ଆଜ୍ଞା
accused is there and
ନାଇଁ ଭୁଲ ଲେଖିଦେଲି କାରଣ ଲୋଅର କୋର୍ଟରେ ସେ ସେଟା ଲେଖିଛନ୍ତି.
don't write that.
My lord, it
Do
should have
whatever.
been free of. 207 says it is free of cost.
Obviously,
My lord, କିନ୍ତୁ ଆଜ୍ଞା ସେ ଲେଖିଦେଇଛନ୍ତି ତଳ କୋର୍ଟରେ ଆଉ.
free and fair trial.
free and fair. ସେଟା ଲେଖିଛନ୍ତି ତଳ କୋର୍ଟରେ ଯେ ଆମ କଷ୍ଟରେ ଦିଆଯାଉ, so I
207 also.
For the
ଆଜ୍ଞା.
Chalo.
Your lordship may add that without any cost it may be supplied.
And that I'll not.
Obliged, my lord, highly obliged.
The order dated 23/8/2023. Part by the Lord and Obedient Sambalpur in connection with 16 case number 1.
Yes, yes. What is the case?
130 and I think. The background of
Use the mic.
mic.
Use the mic. I can't hear.
The background of the case is that present petitioner has purchased a vehicle from the complainant mailer, and thereafter he received the vehicle without registration number and a insurance mailer. Thereafter, vehicle was returned, and he has paid for one installment, and thereafter the company has seized the vehicle, and thereafter issued notice to the present petitioner for appointment and arbitrator as per the clause 29 of the
Okay.
their
Then
agreement.
what happened on this 23/8/2010?
Thereafter, yes, initiated a arbitration proceeding, my lord, and suppressed all the things. He had filed the 138 NI Act, and using my check, which was given at the time of sanction of a loan 4 years back.
Issue notice to the opposite party, number 1. Returnable within 2 weeks. 2 weeks.
I am further.
Notice on IO. Notice on IO. You serve within 2 weeks, we'll do it. Yes. Read this. 2 weeks up.
Registered postman.
20. Yes.
Item 9.
Let item 9, may I please, your lordship? Your lordship kindly see page 13, it is a Belgium matter, my lord. On 17/7/2019, my lord.
When you were on the bail? When you got the bail?
Bail, my lord, I have enclosed, my lord.
Wait, tell me the date.
My lord, date, my lord, on 26/11/2014, my lord.
26/11/2014. NBW dated?
Dated, my lord, 17/7.
17/7. 17/7.
17/7/2019, my lord.
2019 is
Man.
coming now. How much you will pay?
Very poor man, my lord. He, my lord, staying in Surat, my lord.
Anybody
working-
engages you will become poor.
1,000, your lordship.
1,000.
1,000.
1,000. Okay, next. 20th.
Item 10.
May I please, your lordships? My lord, the petitioner is the registered owner of vehicle number OD 19W2363, which is a Bolero pickup van, my lord. The vehicle was involved in the MMDR Act, for which the vehicle was seized. Thereafter, being the registered owner, the petitioner moved an application for application under section 457 of CRPC before the land.
What happened?
My lord, in revisional code annexure 3, my lord,
Vehicle was released.
vehicle was released, but the
What's the
condition imposed, my lord, page 20,
Yes. What is
7th line. Accordingly, the
Owner
petitioner
of the vehicle shall furnish cash security
and
or
bank guarantee as per the value reflected in the tax invoice.
either bank guarantee or bill security? What is this both?
Your lordship.
What will you give?
My-
Cash security or
my-
bank guarantee?
Property security କରନ୍ତୁ ସେ a very poor man my lord on finance the vehicle was purchased ଆଉ tax invoice ଯୋଉ rate ଟା କହିଛନ୍ତି tax invoice ରେ my lord kindly peruse 9,52,000 ଅଛି ଏଠି ଦେଇପାରିବନି ନୂଆ vehicle ରେ କିଣିଲା ସାଙ୍ଗେ ସମାନ ହେଇଯିବ 1 year vehicle property security ଟା କରନ୍ତୁ
What are you doing?
my lord just ଏଇଟା ତ ଗାଡିଟା କିଣିକି ବର୍ଷେ ହେଇନି finance ରେ ଆଣିକି ସେ
ଗାଡ଼ିଟା କିଣିକି ବର୍ଷେ ହେଇନି ତ କାହିଁକି କାମରେ ଲଗେଇଥିଲେ?
finance ରେ ଚାଲିଛି ସେ
କାମରେ
driver
ଲଗେଇଥିଲେ କାହିଁକି?
my
What
lord
is the valuation of the vehicle?
vehicle my lord
You are
9,52,000
an accused.
my lord
You are an accused.
yes my lord
କଣ କରିବେ?
କିଛି ଦନ୍ତୁ କ୍ୟାସ୍ ଆଉ ଇଣ୍ଡିପେଣ୍ଡେଣ୍ଟ ପାର୍ଟି ଯିବେ କିଛି କ୍ୟାସ୍ ରହିଲେ ଗାଡ଼ିର ଏଇଟା ରହିବ
How much you will pay?
my lord 50,000 କରନ୍ତୁ
Huh?
50,000 my lord
50. What is the value?
value 9,52,000 ଅଛି invoice ରେ tax invoice ରେ 1 year
Vehicle
vehicle
shall furnish a security bank guarantee value of reflected. 1 lakh you pay cash security and remaining ये ठीक है?
my lord.
The petitioner has challenged the order dated 18/7/2023, whereby the application under 457 CRPC, although was applied, although was allowed, but with the condition that he shall furnish cash security and bank guarantee. Guarantee as per the value of reflected in the vehicular documents. So the valuation of document was made, valuation of the vehicle as per the invoice was has been calculated to be 9 lakh,
52,520
9,52,520.
520
520. The counsel for the petitioner submits that the petitioner has purchased his vehicle, obtaining loan from the bank, and he has been paying installment. But unfortunately, he is entangled in this case. So therefore, a lenient view should be taken. Taking into consideration the facts of the present case, Mr. Ragada appears for the state and submits that there is no legal impediment to take a lenient view. However, some security in the nature, some security for release of the offending vehicle should be imposed. Full stop. Next, accordingly, the order dated, impugn order dated 18/7/2023 is modified to the extent that the vehicle may be released to the owner of the vehicle may be released to the petitioner who claims to the owner of the vehicle by subject to the furnishing cash security of 1 lakh rupees and property security of 8 lakh rupees, 8 lakh rupees, along with a indemnity bond for the entire amount. With such modification, the impugn order is set aside.
Obligatory.
Yes.
May I please, Your Lordship, my lord? In this case, my lord, the petitioner is challenging order dated 26 July 2023, my lord.
What happened?
The allegation is, my lord, the complaint, the petitioner is the agent of the OP number 2, my lord, who is a company. And was collecting money from the general public and deposit the same in the company's account, my lord.
So what do you want? This is what is this? Your prayer is
Passing of affair, my lord, without taking cognizance, my lord, the OPAD court, my lord.
Paid my lord, paid counsel.
and otherwise also
We have to drop copy
you are the agent, then you are collecting, then you are responsible.
She has to
I am not
serve
agent,
copy
my
to
lord.
paid
You
counsel.
serve the copy to the OPAD council. Let us see.
Okay.
Put it after 2 weeks. Learned counsel for the petitioner undertakes to serve the copy to the council for OPAD. Who? Mr. Swai,
Mr. Bhuya,
Mr. Bhuya.
Vivekananda Bhuya, Mr.
Vivekanand Bhuya. Let her do so within a week, leaves the matter of. Next.
Item 12.
Yes. Possible.
13.
Wait, please, my lords.
Yes.
Lords, here I have challenged the order taking cognizance which has been passed without appreciating the fact that the CE report was not available, for which your lordship had sought for instructions on the last two occasions in the
Yes.
council.
My CA has already received.
Huh?
CA my lord already received, my lord. On 12/1/2024. Already filed.
That's
Subsequently filed, my lord.
No, subsequently filed how?
My lord. They have obtained the same subsequently and filed in the case. Lower
How
court.
have you filed?
My lord.
There is a procedure
My
for
lord.
filing.
My lord.
What generally?
He has not filed at the time of filing with the case, my lord.
filing of the charge
Case is
sheet.
kept open, my lord.
Kept open.
My lord.
You have filed a supplementary charge sheet.
My lord. Subsequently filed the CA report.
No, you have, be sure about it.
Vice my lord, preliminary
Or
charge sheet
simply 173.
preliminary.
charge sheet first. Subsequently, my lord,
Thereafter you filed it.
keeping open the investigation, my lord. Subsequently on 12th, my lord, 1/2024, the CA filed.
But generally what they do is,
My lord.
charge sheet is filed, 173 report is filed, 173(8) is not open. They get that report
My lord.
and in a memo they file it. How will you
Here-
introduce a document?
Here, my lord, the investigation open, kept open, my lord. For that, he filed, my lord, subsequently.
Would your lordship see the NDPS Act?
Yes, NDP.
What does it speak about investigation?
Now in the changing circumstances, what do you say?
Lords, my valuable right was affected, my lords, because of this illegality.
That is pending in Supreme Court.
Yes, but I am in custody, my lords.
167(2).
Yes, my lords.
He has
What?
not applied for one system to.
How can I apply for 167(2)? I may be a fool, all right, but I am not.
But for regular bail, this may be a,
Regular bail, my lords, there may be hitches. But this, I was entitled to go out on bail. But because of this illegal attitude of the investigating agency,
the law is not yet settled. That's the problem.
my lords, the law is settled with the introduction of section 167. 167 CRPC says that there is a limit to the period of remand during investigation. And they set a time limit. They don't speak about a preliminary or a supplementary charge sheet. Neither the old code spoke of it nor the new code spoke of it. The difference between the old and the new code was that in the old code, my lords, this 167 provision was not there. That it is to be completed within a particular period, failing which they would be released on bail. So because there was only a 15-day time, my lords, the police manual provided for a preliminary charge sheet. And what the police people used to do was, they used to file a preliminary charge sheet so that the difficulty of obtaining a remand under the old code, my lords, post charge sheet would not be necessary.
Then you have to challenge that remand order.
My lords, that's what I have done. I have done that, my lords.
You say the remand is wrong. You are asking
Quashing
cognizance
of
order to be
cognizance.
wrong.
My lords, I am asking for quashing of cognizance, my lords, because that covers everything, my lords. The order of cognizance could not have been taken on a preliminary charge sheet. Because there is no provision for a preliminary charge sheet. And that has been held, my lords. The lordship says,
Which provision you wanted to show?
the lordship may look at section 36.
NDPS.
Yes.
Yes, 36. Yes.
36, my lords may look at A.
Yes.
36A, your lordship may look at subclause B, my lords. Where a person accused or suspected of the commission of an offence under the act is forwarded
36, 36 capital A.
Yes, my lords.
Capital A, subclause B.
Subclause B.
Oh, 30. Rule. Okay. Section 36. Okay. Yes.
Where a person accused of or suspected of the commission of an offence under this act is forwarded to a magistrate
under subsection 2 or 2A of 167 CRPC, such magistrate may authorize the detention of such person in such custody as he thinks fit for a period not exceeding 15 days in the whole where he is a judicial magistrate, 7 days where he is an executive magistrate, provided that in cases triable by the special court where the magistrate considers that the detention of such person is unnecessary, he will order the person to be forwarded to the special court. We are not concerned much with that. Then your lordship may look at clause D. A special court may, upon perusal of police report of the facts constituting an offence under this act, or upon complaint made by an officer of the central government or a state government authorized in this behalf, take cognizance of the offence without accused being committed to it for trial. This provides for direct cognizance, my lords, by the special court. Then your lordship may see subclause 3.
Yes.
Nothing contained in this section shall be deemed to affect the special powers of the High Court regarding bail under 439 of the CRPC, which the High Court shall exercise. Then subclause 4, your lordship may see. In respect of a person accused of an offence punishable under section 19, 24 or 27A, or for offences involving commercial quantity, references in subsection 2 of 167 thereof to 90 days where they occur shall be construed as reference to 180 days. Maximum period of remand has been doubled. Then, my lords, what it says in the proviso is that if it is not possible to complete the investigation within that extended period, the special court can extend that period. My lords, where was the necessity for this IO to file in this case the charge sheet on which cognizance was taken? Was it essential or necessary for him to do so when he filed the charge sheet, my lords, on 31/7/2023?
Yes, Mr. Ragada, what he's trying to say is, try to appreciate one thing.
What I am saying, my lords, is that
Instruction from the IO.
No, that is that
what
part.
kind of
It is a
instructions?
legal issue. What he says is the special statute. Forget about CRPC. The special statute says that you have to file charge sheet, not preliminary or secondary. Charge sheet within 90 days, or now it is now in the special statute, it may 180 days.
My lord.
If you can't file within 180 days, you have to apply for extension.
My lord.
See, the very fact that there is a provisions of seeking extension indicates that the preliminary concept of preliminary charge sheet and the final charge sheet is
That has been
not contemplated under the act.
my lord, that
So why have you not sought extension and introduced that document instead of introducing subsequently under one
that has
under the aid
taken
of
consideration, my lord, in a reporting case of our own High Court, my lord. This this honorable court, my lord, in criminal serial mission number 2033/2022, my lord. But the permit I will read out this
Give me that.
11, my lord.
My lords, may I suggest one thing? Let me prepare a chart of dates, my lords. Your lordship may call it any other day. I will place submissions in extension.
Paragraph 11.
Thereafter, your lordship can hear Mr. Ragada. What he is relying upon also.
One more thing I can suggest you.
Yes.
There are two options available, apart from what you are saying.
Yes.
One is if you are eager to get bail, I will send it back to the trial court. You apply 439 and raise all these objections.
In 439, I cannot raise all these. I am debarred from raising so. Because in 439, the special conditions come into play.
Then you submit, then I'll decide this. Come with it. You give me the chart and whatever.
Yes.
Okay.
Any day your lordship fixes.
Give it conveniently 20 years. Yes. Next.
Kodi.
But you just
My lord, I have got the decision, my lord.
which special set.
My lord. That has dealt with it.
All statutes, my lords, they are required to be followed
My lord,
as the statute
even if
requires.
I have not prayed for
this is
extension,
a-
my lord. Sometimes preliminary charge sheet.
No, this is being a draconian law.
My lord.
There are a lot of procedural safeguard. You can't ignore the procedural safeguard.
My lord, that is true, my lord. But
Because it is directly infringes the
But
right
the-
of an accused.
they taking into
So
consideration
you should be very, very careful.
two aspects, my lord. 173 and also, my lord, that is
BJP's
say, per a, my lord. The so many decisions are there, my lord. Even if my lord claim charge sheet terminated, that cannot be questioned.
You come with the decision and supply the copy to
My lord.
Mr. Ponda
My
beforehand.
excited this.
I have copies. I don't need his copies.
Copy with him, my lord.
And take
20th.
copies from him then.
On 20th, my lord.
Yes. Next.
Item 14.
Next occasion, you have directed to file a separate petition regarding causing of affair in Chomakandi PS case number 297. They have already filed it, but the petition has not gone.
Not
My learned friend.
The case and counter case, my lord.
Ah,
Both parties filed the case. Causing affair. I have already filed. My lord.
Settle the dispute.
Oh, my lord.
Yes or no?
Yes, ma'am.
You have settled the dispute.
Huh.
Then what happened?
My case are going to be listed, my lord. That is the
Not listed.
No, my lord.
Take the name and number and list it. List both the matters. In early day.
Diary number.
Next week,
Not
we will
listed, man. There must be some defect for that. Isn't it?
Let him cure and
Defect
defect
already
already
removed.
removed.
Then it will.
It will be list it on 12th or 15th or whatever. Next. 15.
Item 15.
Lordship. Now for the petitioner, seek for an adjournment, lordship.
Adjourned.
Obliged.
16.
16.
16 may please, my lords.
Yes.
My lord, this is a Belgium matter, my lord.
When you got the bail?
My lord, in anticipatory ABLAPL number
Number forget. They give the date.
16/3 to 2018.
16/3.
2018.
When the
NBW was issued.
when
My lord, 1/8/2023. Annexure 1.
If offense.
Offense, my lord, under section
You will search the
my lord, 341, 294, 307,
Okay. How much? 1,000.
500.
500.
500.
500.
Obliged, my lord.
Yes.
Item 18.
Yes.
May I please note? Earlier, the petitioner was granted with the benefit of anticipatory bail, my lord. In BLAPL number 49.
NBW.
Yes, NBW.
How
NBW
much
has
you
been
pay? You tell me.
NBW has been issued.
24/11/2023.
My lord.
Offense?
Offences are 506.
Okay. 1,000 or 500?
As my lordship pleases.
Then you are capable of paying.
No.
More than 1,000.
As my lordship pleases. I should not bargain before my lordship.
1,000. You must send your junior next time, so that it will be. At least you send junior so that
She is there, my lord.
She is there. She is there.
if she will appear, it will be 500.
She is doing very well, my lord.
You give opportunity in small matter. Why are you coming?
No, just
Once he has
What
come,
just?
he has to pay 1,000.
In the small matters, you should give opportunity to your junior. So
I have told her to do both the matters, but
So
since
therefore, I will impose a cost of 2,000 because you appear. 1,000. Yes.
Item 19.
May I please, Your Lordship?
Yes.
The Belgium matter, petitioner submit. NBW was issued subsequently. Petitioner was on bail. White BLAPL number 3062 of,
Date of bail.
and that is 26/7/2017. White BLAPL number 3026 of 2017.
Why have you moved an application 317 then?
That he was not available on that date. That's why the petitioner has moved the application under section 317 before the court will, Your Lordship, to dispense the personal appearance for the day, Your Lordship.
Okay. How much will you pay?
As the Lordship says.
500. इसमें थोड़ा सा just लिख दो भाई on one line, two line on 4/11/2022. The petitioner moved an application under 317 CRPC. The said application was rejected and NBW was issued by the yes, 500. Okay.
Lordship, there is a defect that may be ignored. There is a defect that may
It's already ignored. No problem. Yes.
My lord, the
NBW
past
was
over
issued
matter.
for the first
I
time,
will
my
be
lord,
pardoned, my
and he
lord.
was he was released on bail on dated 22nd July 2023, your lordship.
Has he come?
Senior counsel, OPD matter, my lord. Appearing. What is-
But he has to come, no?
My-
Here, come. 1 minute, ma'am.
Yes, my lord.
Yes. Item number?
One.
Item 1. Yes. Yes, have you got the copy?
My lord, one extra copy be served on us, my lord. And some time may granted to obtain instruction, my lord.
There is asking time for instruction.
My lord, my lord.
All right, my lord.
Yes.
Your lordship
Then,
may fix.
Yes, I will fix a date and then I'll hear you. And he seeks one more copy.
My lord.
Yes, my lord.
Yes.
Yes, my lord will supply that copy. My lord, may I pray this matter be kept to second week of February, my lord?
Okay, second
May
week
I
of
pray?
February.
Yes, my lord.
Second.
Indeed.
You will-
7 or 8, my lord. Can I pray for that? 7th or 8th of February.
7, 8 is very packed. Can it be 19 if you have no problem? 19?
My lord, 19th will be little far. My lord, can it be on 30th?
Okay, let it be 12. 12,
12.
okay?
Okay, my lord. Grateful, my lord.
MP appearance and extra copy will be supplied to there.
Yes, my lord.
Name of the Mr. B. Bhuya may be reflected in the cost title, my lord. Special counsel OPID, my lord.
Special counsel OPID. Wherever the OPID matter is there, reflect his name.
B. Bhuya, my lord.
Vivekananda Bhuya.
Vivekanand Bhuya.
No,
Name has to be reflected. Otherwise, in the other matter was also there.
My lord.
Urgent.
My lord.
Wherever the OPID Act is there, how will you how will you know OPID Act? State of Orissa, then how will you know? Unless
My lord.
anyways, let us see. Next.
Grateful.
20? 20?
20 May, please, lord. Due to non-appearance of the petitioner, my lord, NBW was issued, my lord.
Yes.
And he was
What is the offense?
20 B of the NDPS Act, lordship.
Acha, you are on bail?
Bail on 22nd July 2023, my lord.
22nd July bail. Huh? You will surrender before 20th, huh?
2023.
23. NBW on 17/11/20. Okay. How much?
500.
500.
21.
21 may I please hold. Say, Belgium matter, around 37/2019 NBW was issued.
No, bail?
My lord, bail exactly, I don't have the knowledge, but from the order sheet.
You are on bail, na?
Yes, yes, from the order sheet.
Simply you write the petitioner is in bail and facing trial in such case. NBW issued on the 30th July 2019. July annexure 1. 2019 now you are coming. So more cost. 1,000. 2019 now you are coming. So therefore 1,000. Okay.
My lord, this is a Belgium matter and the NBW was issued on that 19/12/2023.
When were you in bail?
I have released on bail on dated 3/3/2017. I had BLA PLA now 217.
NBW 19/12/2023. Bail के वही थी ना? 3317.
3/3/17.
How much? 5.
My lord,
500 1,000.
500.
500. Yes. 23, 7/9/23. NBW. NBW होची 7/9/2023. ठीक है जी? 500. Yes. 24.
May I please, lordship. Petition saying to passing of a criminal proceeding
In view of the compromise between the parties, my lord, all the offense are.
What is the offense?
All the offense is trial magistrate, 448 to 94,
Okay.
233.
Okay, who all are the notice was issued?
My lord,
Parties are there?
parties are there and joint affidavit also filed.
Write down. The notice was issued earlier?
No,
My
no,
lord,
fresh
case
case,
matter.
fresh case,
What do you say?
fresh case.
Yes. What do you say? Do you want to say anything?
All the parties.
Grievous injury ଅଛି, but
Grievous injury 323 ଥର କରିଛନ୍ତି ଆଉ କଣ?
ନାଇଁ ଏଇଟା ଫ୍ରାକ୍ଚର ଅଛି, ହ୍ୟାଣ୍ଡ ଫ୍ରାକ୍ଚର ସେ ଆନେକ୍ସର କରିଛନ୍ତି।
307 ନାହିଁ ନା?
ନା,
ଚାର୍ଜ ସିଟ୍ ଫାଇଲ ହେଇଗଲାଣି?
Charge sheet, it has not annexed the charge sheet.
There are counter FIR, there are 2 FIR.
Yes.
What happened to the
Another affair, noxious in the London trial.
compounded? Compoundable offense.
My bad.
The petitioner has filed this present petition under 480 CRPC. seeking passing of the FIR number 355 of 2023 PS Rajukanika Kendrapura. Under section E. It appears there are a counter FIR filed by the opposite party. Opposite parties against the petitioner. Insofar as the counter FIR counter FIR number
354.
354 of 2023 in PS Rajkanika Kendrapura is concerned. The land council for the party submits that they have compounded the offence before the court below. The parties have now settled the dispute with themselves and filed a joint affidavit before this court, reaffirming their stand. Reiterating the fact of settlement. On the basis of the said settlement, they seek enforcement to the FIR in subject. The parties are represented in court and represented by their respective counsel. So they are identified by their counsel and the parties have also filed the Aadhaar copy. Is there any problem?
verify goods.
Naturally, lady na
ସେ ଫାଷ୍ଟ ମନା କଲେ ଯେ ମୁଁ ଏଫଆଇଆର ଦେଇନି। ଆମେ ଆସିନଥିଲୁ।
ଆପଣଙ୍କ ନାଁ କଣ?
କୁହନ୍ତୁ କୁହନ୍ତୁ।
ଚନ୍ଦନା ସାହୁ, ଅପୋଜିଟ୍ ପାର୍ଟି ନମ୍ବର 2 ରେ। ଠିକ ଅଛି। ତମ ନାଁ କଣ? ଜଗନ୍ନାଥ। ସୋମନାଥ ସାହୁ ପଢାଲେ।
Unfortunately, did not come. Present petitioner.
ନିରାକାର ସାହୁ। The parties जो लिखा है ना, parties are present. देखो, the petitioner number 1 and opposite party number 2 and 3 are present, represented by their respective counsel, and they file their Aadhaar card. Yes, ठीक है। The letter of Mr. Maharaj appearing for the state submits that the parties have now settled the dispute and filed an affidavit. Although the medical report indicates grievous hurt,
hand fracture.
Medical report indicates grievous hurt, but the FIR is lodged under 323 IPC, and the investigation is still on, full stop, still on. However, the parties have now settled at on the intervention of the village entries, and they don't want to proceed with the matter. Proceed with the matter. Next part. Taking into consideration the aforementioned facts and submission of the bar, I'm of the view that the putting the accused persons to trial in the instant case would be a futile exercise since the parties have settled their dispute. Hence, the FIR number so and so, under section so and so is passed.
May I please, Mullah? I'm operating through virtual mode, Mullah. Mullah, hearing we have challenged the order dated 12th of September 2006 and dated 24th of August 2022, by which order NBW was issued against the petitioner, Mullah.
Okay, when you were on bail?
I was enlarged on bail by the Honorable Court on 8th of December 2004, my lords.
Look, 8th December 2002.
No, my lords, 2004.
8th December 2004. He was on bail. Okay. NBW issued on?
NBW, the order to issue NBW was passed on 12th of September 2006, but it was not executed, my lords. And thereafter, on dated 24th of August 22, it was a fresh order was passed to execute.
Okay, 24/8/2022. 24/8/2022.
No, that is 2006 NBW.
But it could not be executed again 22nd.
Fresh NBW. But that NBW, it is subsequent to NBW.
Fresh NBW is issued, then if that is cause, everything goes. Both the things will. Both the things. इसमें लिख दियो. The court below had issued NBW against the petitioner on 12/9/2006, 12/9/2006, which was not, which could not be executed, and eventually on 24/8/2022, fresh NBWs have been issued. The petition. And the petitioner is challenging both the orders. Taking into consideration the facts and circumstances of the case, the impugn orders dated 12/9/2006 and 24/8/2006, whereby NBW has been issued against the petitioner, is set aside, subject to the petitioner appearing before the court below and availing remedy under law available to him by 20th of February 2022. The petitioner is liable to the said order is subject to the petitioner paying the cost of rupees 1,000. Okay. Okay.
Is it 1,000, my lords? Is it 1,000, my lords?
1,000.
Grateful, my lord.
And he appeared before the court before 20th February.
Grateful, my lords. Grateful.
26 ballot page 12 on 15/11/2023.
15/11/2023. 22 bail.
23. NBW was issued.
Bail, when you got the bail?
Then Lordship earlier was on bail, placed then Lordship on 6/10/2023. He was allowed on the fresh condition. He was allowed to be released on bail on the fresh condition. 6/10/23, Lordship placed 10.
Yes, 10.
Thereafter, on the first day after commitment, the NBW was issued.
On 6/10/2023, right down, on 6/10/23, petitioner was enlarged on bail with certain conditions. However, he has failed to comply with the condition and did not appeal in the court, which led to issuance of NBW on
15/11/2023.
15/11/2023. 23. The petitioner, next, the petitioner is undertaking to appear before the court on or before 20th of February, so and we will remedy under law.
So far, petition number 3 is controversial.
How many of you are there?
4. Yes, not plus lawsuit is already in custody, has taken, but it will not be taken up due to the length of the site.
So far as the petition number 3 is concerned, he is already in custody. So therefore, this petition number 3 is not fresh. The order dated, which is that order dated? Order dated 15/11/2023, passed by the special judge Bhadrak in ST case number 316 of 2023, that aside, subject to the petitioner paying cost of ₹1,000 each. 500 each. See, 3 of you are there. Not 500. To be paid to the High Court welfare resolution. Yes. Yes.
May please watch.
Yes.
One of the petitioner challenges to order of convenience taken against him under section of Washington kindly see page 10, good deed.
Yes.
Finance charge sheet number 256, that was 61, order section 366, 3762, L 506, 363, 109 IPC against the appeal persons, namely Rajesh Rao, Ranjit Singh, is received with the case records. It is seen that there is prima facie evidence well made out under section 363, 366, 376 to N, 344, 506 IPC against the accused.
You are Rajesh.
I am Rajesh, my lord. Next line is, my lord, Rajesh Rao is liable under section 363, 366, 109. Lord's may kindly see 363, my lord.
No. The first provisions, Rajesh Rao is the cognizance is taken in all the sections. In the initial line against Rajesh Rao also.
Rajesh Rao, Ranjit Singh is received. Peruse the case. It is seen that there is prima facie case is made out against under section 363, 366, 376 to N against Ranjit Singh.
And other.
And no, man. And other accused Rajesh Rao is liable. Sentence like that. And other accused Rajesh Rao is liable. Next sentence, man.
363, 366. And
yes, man. So Rajesh, cognizance is taken against Rajesh Rao is under section 363, 366. Lord's may kindly see 366, 363. Lord's not kidnapping a minor girl. Must be below 16. Lord's may kindly see the affair which has been lost by the guy, victim girl herself at page 14.
Yes, page 14.
Yes, madam. Maheshwar Ambhe Kalakarni Kumari Madhusmita Modi was a 4 years. The question of application of section 363 of the data is totally misconceived.
363 and 360.
363 also kindly see 363, 366 also not applicable. But first of all, also kindly 363 minor. 363 minor. Punishment for kidnapping.
Yes.
And kidnapping is defined, my lord, under section 359. Kidnapping of 2 kinds, 360 kidnapping from India, it's not applicable. Kidnapping from lawful guardianship. Whoever takes or entices any minor under 16 years of the age,
you are ready? 369.
361. 361, mine.
361 is all right. 361.
The definition of kidnapping.
Kidnapping from lawful guardians.
Or under the 18 years of age, if he is a female.
Kidnapping from India. Kidnapping from guardians. Yes.
So my responsible submission magistrate has not applied in my matter. Kidnapping a minor girl at 363. The girl says that I'm 20 years. The question of application of 363.
366.
So for 366 is concerned, my lord. That is also
Who were kidnapped, abducted in women with intent that he may be.
Absolutely no allegations, my lord. I had a talk with her. I had a talk with the man accused. I had a talk with my lord from the mobile phone. They had found that at that time, at a particular time, I had a talk with the accused persons. What is that talk? They need to know, my lord. So for which, my lord, I have been also implicated as an accused on the
But 109 under the date
Yes.
of 109 has been.
Yes, 109.
The other offences are
Yes,
there.
my lord, 109. Only because
You argue on charge.
Pardon?
You argue on charge.
Charge. At 109 also prima facie.
Cognizance order cannot be quashed because see 10 under the aid of 109, you have been
If it was not my lord, application of mine.
That is why stages are defined. Who knows better than you?
Without the your lordship,
Who knows better than you?
without application of judicial mind, my lord, cognizance has been taken.
So 109 is there. That's the reason. 109 under the aid of 109, the cognizance has been taken.
109.
So therefore, you can separate it at the
No, my lord,
stage of trial.
109, there must be private facie something to show that there is an abatement. Nothing, my lord. Nothing is there.
Page 32,
I have annexed the charge sheet.
32 your lordship, may kindly
I have annexed the charge sheet, my
Page
lord.
32.
Why do you? Yes, page 32.
Page 32.
Yes.
This has been elaborately discussed and
At the stage of
judicial order has already
bail.
been passed. A bail application
Yes,
has
which
been
para?
rejected. On perusal of the final,
That is
para five.
anticipated
Para five.
rejected.
On perusal of the final form, it reveals that Ranjit Singh has been shown as the only accused, though the investigation is kept open. Earlier, this court had declined to grant anticipatory bail to the petitioner on the basis of the statement of the victim recorded under section 164 CRPC. Since learned counsel for the petitioner had on the submission of the charge sheet, where the petitioner has not been shown as an accused, this court finds no ground of apprehension of arrest. Hence, this court is not inclined to grant anticipatory bail to the petitioner.
Yes, I'll
Viewing it earlier.
keep that liberty.
That is anticipatory bail, my lord.
It's all right. I'll give a liberty. Cognizance order can't be quashed.
And a lordship may kindly
Just a minute.
turn to page 30. Page 30. I have not completed. Page 30.
30.
Yes.
Hmm.
Para 7.
30.
Para 7. Same accused.
That is
Same accused.
That is anticipated bail.
According to learned counsel of the state, the informant victim has undergone a trauma.
173, 176D is there. 109 is there. Cognizance has been taken.
No.
And
Cognizance
one-
of
164
376D, my lord. So far, this petition is concerned, cognizance is taken only under section 363, 366 by 109.
Page 27.
109 under the aid of 109, 173(6)D will also come.
My lord,
Because the abatement.
no, my lord, your lordship 370, your lordship.
Abatement to commit kidnap,
And so far,
rape and everything.
and so far,
At 109 means you abated, then
And
how
so
will you
far-
escape out of it?
no, my lord, so far abatement is concerned, there must be something, it must attract section
In
107.
cognizance order, I can't go into evidence as simple as that.
True, my lord, but there must be prima facie case for the magistrate to apply the judicial mind and to take cognizance.
You see,
Marriage
FIR
Is
says
there the prima
that
facie
you
case?
have argued that in anticipatory bail stage, there is some observation. And why should I, at a cognizance order can be quashed?
Anticipatory bail, my lord, say different relief and so for quashing.
Better you should argue in the charge. That's the better thing. I just, you withdraw, I'll indicate that. Then we should hold the rank and counsel, senior counsel.
Well, may I pray, my lord?
Seeks to withdraw this petition to raise all these points, all the points he has raised in the, at this stage, at the time of argument on charge, argument and charge, with this liberty, the petition is dismissed and withdrawn.
Disposal of your lords must dismiss.
Dispose up with this liberty.
I will protect my lord.
I've disposed up, once disposed of, no protection.
Your lordship.
And I have made it a standard principle in a 482 petition, no interim orders. To satisfy me, take the order. Because see, this is short circuiting 438, short circuiting the other provision.
482, my lord, the power is
The power is there.
inherent power of your lordship can any power.
Yes,
pass
power,
any order, my lord.
power is there.
If it is abuse
In
of process of court.
the extreme cases to meet ends of justice, I'll do it. But where there is repeated attempt to get 438 relief and the court is declined, and 482 is
Four
started.
38 declined, my lord, because anticipated bail was not granted. But if no prima facie case is made out for a particular offence, my lord, there is no bar for your lordship, my lord, to exercise the power under section
438,
482
438
to prevent the abuse of the process of court.
See, 438 is declined because there is prima facie case.
Oh.
So therefore, the High Court rejection of the High Court order saying that prima facie case against you, so therefore I will not give 438 relief. And you challenge that the magistrate's order cognizance. The very fact that you lost it in two opportunity, 438, indicates that there is prima facie.
By that time,
And trial court is correct in taking cognizance.
by that time, charge sheet was not filed, my lord.
So why should I write all this thing?
While 438 application was filed, by that time, charge sheet was not filed.
But
After
see, this is the danger coming to High Court at the 438 stage. You should go to Sessions Court always.
But 482 with utmost respect, and I must submit.
You can move in a separate application also for discharge.
The problem is, my lord, the principal accused has been released on bail. I am not on bail, my lord, because my anticipated bail was rejected, my lord. The moment I will appear, I may take into custody.
I know your difficulties, but what can be? Cognizance order. Okay. Thank you, sir. Bail order. Yes, next. 30. 20. I'll just
Bail, my lord, 2017.
Huh?
2017.
There must be some date.
Date code. BLAPL number 4696 of 2017 allowed on 11/8/2017, and another one is BLAPL number 4680.
Another means how many?
Two accused persons.
Acha. The accused who got the bail what time? Kanu, Dalai, Digal. Kanu Digal when he got.
Copies of the thing. Kanu Digal one on BLPL number 46969617, dated 11/8 of 2017.
Petition number 1 stated. Next. Petition number 2.
Next is, my lord,
Anil Digal.
BLPL number 4680 of 17, dated 25/7/2017.
And NBW issued against both of you on 14/12/2023. NBW. Okay. 20th you will appear. Before, on or before 20th February you will appear. Okay. 1,500 each. Yes.
49.
May I please, Ross?
Yes.
It's a Belgium matter, my lord, order dated 61.
Bail, when you got the bail?
11/12/2019.
11/12/2019. And
Order dated 16/1/2024.
16/1/2024.
24.
ये NBW. ठीक है? 500.
Obliged, my lord.
Yes.
30.
On behalf of Big B Rautra, order dated, my lord, 4/11/2015, NBW issued, my lord.
Yes, you got the bail when?
Bail, that instruction not there, my lord, 2000.
Are you on bail or not?
Yes, my lord.
He is on bail. Petitioner is on bail. And bail for he's facing trial. Agree? And he did not appear. Who? You didn't appear, huh?
One is there is
NBW was issued on 4/11/2015. So 15.
Yes, my lord.
Now you are coming.
Yes.
Why?
My lord, that NBW is not executed, my lord. That's why the present petitioner is not knowing about it.
NBW was issued by the court below on 4/11/2015. However, the same appears to have not been executed. The petitioner has challenged the said order belatedly in this petition. Maharaj, कौन करे यार? Usually he has to face the court.
Yes, yes.
1,000 for the obliged. How many of you are there?
Pardon, my lord.
What is the offense?
There are two persons, my lord. In the meantime, one accused already dead, my lord. Already dead.
307 and all you appear before the court on or before 20th and avail remedy. Avail remedy permissible under law.
500 cost.
1,000.
1,000.
For 2015 order.
Yes, yes. 5,000. 1,000.
Yes. Yes.
May it please, Your Lordship. I am through Vesiman. Your Lordship.
Yes.
My Lord, here the petitioner challenging the order dated 4th January 2024, my Lord. Here he prayed for default bail before the learned court below. After the dismissal of that order, he prefers this application, my Lord. My Lord, without chemical examination report, my Lord, the final PR submitted.
But it's not maintainable because it's a bail application has been rejected. You will also make kindly turn to page 41.
I have never prayed any bail before this
order dated 4/1/2014. 2024. The bail application dated everything is filed on behalf of accused petitioner Manoj Kumar. The petitioner is Manoj Kumar. Bail application. There is no such default application. 167(2), there is nothing. And it's a bail application. So after rejection, this should have been.
You are challenging bail application in 482.
The 483 bail application.
My Lord, I preferred 167 subsection 2 application before the learned trial court. My Lord, I am not the scribe of this impugn order, Your Lordship. Your Lordship make.
No, see your prayer. See your prayer. 4/1/2024 order. That's the order Mr. Maharaj is pointing out at page 41.
My Lord.
Which says it is a bail application. If the bail application rejected, you will file 482 for.
My Lord, I have the copy of the.
You have a better place and bigger place to go.
No, my Lord, I have the copy of the bail application, default bail application, my Lord. I have the copy of the default application. If Your Lordship direct, I will file the default bail
You file it,
application.
sir. And you should have told the court, I have not moved application under for bail.
My Lord, the court mentioned in the order sheet, Your Lordship, may kindly peruse para.
Where is your application? Show me.
I have not appended that application with this 482 application, my Lord. but I filed under 167 subsection 2 before the learned court below. And my
Unless,
one
unless
submission, my
something is
lord,
there on record, I can't help you.
And
My
a
one
very
submission, your
particularly
lordship,
page 43, accordingly, the bail application filed on 22/12/2023 for accused Manoj Kumar stand rejected. Supply a copy of this entire order to the accused petitioner. Bail
your lordship
application
may
has been
kindly,
rejected.
your lordship may
One
You
kindly,
place,
167(2).
you place that application
ଆଜ୍ଞା
which was
ମତେ ଟିକେ
rejected.
କହିବାକୁ ଦେବେ ଆଜ୍ଞା, otherwise ଆପଣ ହିଁ place
No,
କରନ୍ତୁ.
you
Sir,
file that application
your
first. It is bail.
lordship may kindly peruse.
Initially the court says bail application, it rejected bail application. You
My
are
lord,
saying
I am not the scriber of this impugned order, my lord. In the page number 41, the learned court below mentioned the learned counsel for the petitioner submitted that the IO has submitted final PR without any chemical examination report. In this impugned order, he mentioned, my lord. But in the past paragraph, he mentioned that this is a bail application. I never filed any bail application before the learned court below. I filed default bail application, my lord.
if that is your case, you should have moved you should have placed that application on record
I will
and
file
make
the
averment.
addition-
Where is the averment in the present petition that you have moved an application on 167(2), and whereas the trial court rejects my that
Your lordship may kindly turn to page number 5, my lord. Para 5, your lordship. Following the prejudice and bias proceeding against the petitioner on 22/12/2023, the petitioner preferred an application for default bail before the Court of Learned Session Judge, Special Judge at Cuttack in 2ACC number this with the prayer to release him on default bail. And on 4th January 2024,
I understood it. I understood what he might have made the prayer that grant me default bail. 167(2) application generally is moved. They say that grant me default bail. There is no concept of default bail.
Yes.
Instead of default bail, he might have written default bail. The trial court has rejected, saying that
application ta file करते हैं application ना दो ना
you file the within 1 week. File the application.
My lord.
File the application.
Your lordship may kindly call for
And just
the-
see what happened to that judgment in Supreme.
Yes, that is pending, and I am also having the recent judgment of the Hon'Ble Court. That has been not maintained, it has been rejected because once cognizance taken, he has no case.
Even if
yes, and in the meantime, chemical exam report has been submitted.
This is the CLMC and directly the person to move.
And you will also may kindly have a glance.
Regular bail,
ये देखो.
Which
Regular bail, everything has been discussed
in this case.
Yes, similar case, total ditto case.
Which case?
Charge sheet submitted, cognizance taken, chemical exams report filed.
What is this? 31 item? Is it
Yes,
Manoj?
31.
No, it is not Manoj Kumar. It is
No, exact same case. Similar fact.
My lord, your lordship, which case learned state council referring, my lord?
generally these orders are passed. You go and raise all these
Because
things.
the case is pending, that is why this order has
They haven't supplied the
cannot be done.
11-12 batch. Similar things. One system rejected, thereafter come to this one before this one directly.
Let him place on record, we'll see.
Yes.
Get the judgment, we'll see.
Yes,
My lord, our
Let us find out some way out, because the dependency, what best could be done.
your
We'll
lordship,
see.
I have
Leave a date, 16, 17. You place it on record, everything. Mr. Sahu, you place it on record, we'll see. Yes, next item.
32. Please, Shimala, this is a Belgian matter due to wonder default, my lord. Now, NVL has been issued against the present.
Yes, bail, when you got bail?
My lord, he was released on bail by the trial court on 22/6/2018, my lord.
22/6/2018. NBW issued on 4/12/2023 of 500.
Oh, black.
Yes. Next.
33. That is the prison. 130 NI Act proceeding, madam. My application or sense of 205. Therefore, attending the benefit available on 205.
Why are you not appearing in BC? Appear in BC.
Lordship, may I allow to appear?
No, I don't issue notice.
All lordship, may I suggest another thing? But
Why don't you? What is the check amount?
4,34,500.
You pay and finish it up.
Yes, sir.
Huh?
Yes.
I'll issue notice.
Yes.
Returnable within 1 week.
Yes.
You come with the check and give it, finish it up. Yes. Will you come with the draft? No check. Nobody will trust you.
Not certainly.
Nobody will
Check
come with draft.
Good check also.
Come with draft, we will persuade him and finish it up. Yes.
Yes, that.
Okay. And with some cash amount also to persuade him, give the check amount along with that some cash amount so that 20,000-30,000 somewhere around that you give and finish it up.
Okay.
If you notice returnable 13th. Yeah, 13th. Okay.
34, 13. Let's say till then, and may not be.
Till then, have you moved application?
Pardon, sir?
Application you have moved.
Yes.
Yes. The present petition is arising out of a complaint under 138 NIA initiated by the opposite party against the petitioner. The alleged check amount is 4 lakhs.
4 lakhs 34,000.
4 lakhs 34,000.
4 lakh 36,000.
36,000. 4 lakh 36,000. Then counsel for the petitioner submits that his client is ready and willing to make good the payment.
Check amount.
Make good the check amount.
Yes.
Make good the check amount. Check amount. Issue notice to the opposite party. Next paragraph in the interregnum, the NBW issued by the learned court below on 21/6/2011. 2011.
Yes, sir. Get it.
You have successfully avoided not paying such
No,
a
no, Lord.
enjoyed his money for 1 decade,
No.
and now you are coming and paying. I'm ready to pay. You have to come with some money.
What happened, Lord? The case.
How much interest you would have earned by now?
No.
How much will?
What happened? This case is not maintainable also because
Okay.
Merit upru gala merit upru
He has enjoyed the money for 1 decade. Now he will pay.
What happened?
Anyway, I am saying it. Okay. What is that? Shall not be executed till the next date of court. ऊपर तापर लिख दो. There is a since there is a ऊपर तापर not shall not be तापर लिख दो. Since there is a possibility of settlement.
Yes.
In the instant case, the NBW issued against so and so is.
A petitioner is ready and willing to pay the.
Ready and willing to pay.
I have also stated in my petition.
Yes, he has stated. Yes.
Yes.
34.
My lord, here a notice under section 41 was given to me.
Yes, 41A.
Yes. That was a notice issued by the cyber police station at Gurugram. My lord, 41 notice has been given, but I have to take a transit bail because I will appear before I am ready to appear because your lordship will kindly see.
What are the offences?
Offences 420 and 406. My lord, in case it's a case where I should have taken a transit bail because I need a transit bail so that I can go and appear before the author.
You are an accused.
I have been given a 41 notice. There is no FIR. FIR has not been sent. Your lordship may kindly turn to Annexure 2.
What is this Annexure 1 then?
Annexure 1 is the I had gone to the Delhi and I had lost my wallet, laptop, passbook, Aadhaar card, and some of my bags and baggages. From that, I lost an FIR that I have lost. That is what the FIR was lost. And from my laptop and ATM card, they could trace that there is some connection with some other persons where there a fraud has been committed under 420 and 406. So, a notice under section 41 was given under Annexure 2 at page 8, fixing the date of appearance at 9/1/24. My lord, now, unless I get an in transit bail, I cannot appear there. My lord, there is a judgment covering this field of this honorable court. Your lordship may kindly.
You don't have a FIR against you.
No, they have not provided. They just gave me these two papers.
Give him a copy.
Yes.
Yes.
এটা ଟିକେ ଦେଖି ଦିଅନ୍ତୁ ମୋ ପାଖରେ ଗୋଟିଏ କପି ଅଛି ମୁଁ ଦେଇଦେବି ନା ମୁଁ ସେଟା ସେ ଭୁଲ କରିଛି ସେ ଆଉ ଗୋଟେ କରିବା କଥା
That is a 438 petition.
yes
430.
I am aware my lord it's a 438 but here I am before your lordship seeking the same relief that I will your lordship may as per the relief granted in that reported case I may be given the
I
same
will only say that you undertake to appear before the
Yes.
court, and meanwhile you will avail the remedy available to you under law.
that will
What do you say?
not to arrest me
I'll
given-
record his statement that he will appear before the
Concerned-
court,
concerned PS.
concerned PS,
Yes.
and avail the remedy available to him in that.
Yes, yes, yes.
till that period I may be given that protection because your lordship may kindly see that order সেটা ଟିକେ দেখে মহারাজ
Why have you not gone to 438 court?
my lord because I cannot go to 438 court because I have no FIR is given to me my lord, that is my greatest problem no FIR unless an FIR
FIR
is
is
there
available. I think FIR is available online because
Online,
FIR is there.
checked up it is not available
FIR number
that's the reason I did not go to 438 court because unless I give an FIR I cannot move a 438 application that is my greatest problem in some cases FIR is also not unloaded what can we do my lord and this is not a state in Odisha that I can get an online that is my problem man there are unless I get an FIR last conclusion मैं पढ़ दूं your lordship may kindly see paragraph 15
Yes.
Accordingly, this court directs petitioners shall not be arrested by local police, more particularly Tangi police station for a period of 30 days from today in connection with the investigation and with regard to alleged crime. Further, it is made clear that it is open for the petitioner to approach the competent court where the complaint stroke FIR has been lodged for grant of anticipatory bail stroke regular bail to the petitioner in accordance with law. Further, it is also made clear that in even the petitioner fails to comply with the aforesaid condition and does not approach the competent court having jurisdiction over the matter, the transit anticipatory bail granted by this court shall automatically be revoked. My lord, I want this relief only.
No, what I'll do is, I will not go by this. I'll just simply, I'll protect you for some time.
Yes.
You avail you appear, get the anticipatory bail and apply for.
Yes.
That's a better idea.
Yes,
yes.
Because he is here and it is in Gurgaon.
Gurgaon, yes.
41 notice is there, FIR is not there.
Yes.
Even if he will apply for anticipatory bail, he has to go there only,
Yes.
Gurgaon court.
Yes.
All complications are there. Here in this case, it is within Orissa, so therefore, the petition.
No, this was not in Odisha. This was
Wherever.
this was of FIR of Telangana state. That was of Telangana.
The petitioner has approached this court. When a petitioner is invoked the jurisdiction of inherent jurisdiction of the court on 482 CRPC, confronted with a particular situation. He submits a notice under section 41 A of CRPC has been issued against him by which police station? This is by
My lord, Cyber Police Station, South Sector 59, Gurugram.
Cyber Police Station, South Gurgaon. Gurgaon. 41.1 capital A. CRPC, yeah. 41.1. Allegedly for investigating into an FIR, being FIR number 72 of 2023 under section 406 420 IPC 420 IPC. The land counsel for the petitioner submits that he has attempted, his client have attempted to locate the FIR from the official website. However, he could not lay hand. Therefore, confronting with this peculiar situation, he has approached this court seeking protection. Till he availed remedies under the law. Till he remains under the law. Since the petitioner belongs to petitioner is a resident of Cuttack district of Orissa, and he has no means to ascertain regarding the case being registered against him or not. Therefore, it would be appropriate that he should be protected for how many 1 month?
1 month.
Protected for 30 days. 30 days. 30 days. Meanwhile, he undertakes that he would appear before the concerned police station and cooperate with the investigation. And after getting the FIR, if advised so, he would avail the remedy under law before the competent court of before the competent court of jurisdiction. Accordingly, the petition is allowed with the observations. You go 30 days. You appear before that court, IO, get the FIR.
Yes,
If required, apply for anticipatory bail. If not required, it's all right.
Grateful, man.
30 days.
Well, can it be 45 days so that I get a breathing?
Why this? 30 days also you can breathe.
Well, little more, I'll get a good oxygen supply. That's why I'm saying 45 days.
It's very odd. 45 days are very odd. 30 days is best. 30 days. Because you have relied upon the judgment which says 30 days.
As you know.
That is the reason I got the plea.
As you know.
30 days.
35.
Please, Lordship. The Belgium matter, Lordship. After commitment, Lordship, the petitioner could not appear before the assistant session judge for which the NBW is needed.
Okay. Bail, when you got the bail?
The case 7 Lordship and evidence after order dated 22/10/2022 Lordship. After commitment case record is in city number so and so for offense under so and so, it's received from the
petitioner is facing trial for trial in city case number 423 of 2019 for alleged offense again under section 324/326 307 IPC. Full sir. It appears that after the case was committed to the Court of Land Sessions Judge, he failed to appear in the court, which led to the issuance of NBW on 25/4/2023. Full sir. The petitioner seeks quashing of the said order dated 25/4/2023, passed by additional sessions judge Atagad. Therefore, having taken into consideration and submission made, and he will appear. He undertakes to appear 20th, 20th court. So 500. Next.
36.
36 is same Lordship 18/4/2023 page 7 Lordship.
For the NBW के बेला
18/4/23
18/4/23
page 7 Lordship. Again.
Same committal same.
Yes Lordship. Similar.
Committal गला नहीं चाहिए. ठीक है.
Okay.
500.
37.
The 37, my lord, page 8, my lord. At the date of framing of charges, my lord, I have filed a petition of 317 and time petition. That is not allowed and NBW was issued. Belgium.
20th February, you will appear.
Yes, my lord.
500.
38.
My lord. Compromise matter, my lord. Joint affidavit filed today, my lord. Offenses are below 7.
They are there.
My lord.
What is the offense?
Offenses, my lord, 506, 507.
Okay.
Lord,
who are they?
the informant is, my lord, is present here, my lord. And the accused also present here, my lord.
ठीक है.
File here. Copy of the Aadhaar
Who
also.
is appearing for opposite party?
Opposite party, my friend, my lord.
Two.
My lord.
You are appearing. Identifying?
Yes, my lord. Aadhaar card is here, my lord.
हाँ ठीक है. Lekho, the petitioner has filed this petition seeking quashing of the FIR oblique criminal proceedings in GR case number 1637 of 2022 in Dhenkanal Sadar PS in arising out of Dhenkanal Sadar PS case number 154 of 2022 under sections look at you under section 80 annexure 1 annexure 1 11 page 11 under sections also. The learned counsel for the petitioner कितना number item थी
38.
And learned counsel for the petitioner submits that the parties have settled their dispute and they have filed settled their dispute. Mr. Dwivedi is appearing for opposite party number 2 and the parties have
On behalf of Mr. Vidas.
On behalf of Mr. Vidas. The parties have now filed a joint affidavit dated 30th 1/2024, which is taken on record. In the said affidavit, they reiterate the fact that they have settled their dispute. They don't want to continue with the criminal prosecution. The parties are appearing in person. They are identified by their respective counsels. They filed their self-petition copy of the Aadhaar card to establish their identity. Mr. Ragada appears for the state and submits that since the parties have settled their dispute and there is no serious allegation in the FIR, and most of the offences are compoundable in nature. Therefore, there is no legal impediment in quashing these proceedings, criminal proceeding. Taking into consideration the aforementioned facts and submission at the bar, the FIR number so and so, and the consequential proceeding arising therefrom are satisfied. ठीक है.
39. My lord, may allow to take on the next week, my lord. My lord, may allow to take on the next week, my lord.
Adjourned.
40.
Let me kindly see the noting. This is the case wherein that lawyer was involved, Milords.
Then I should take seriously.
Milords.
Lawyer involved in a criminal case should be very serious.
He had accompanied the main accused, Milords. He is not, there's no vote attributed to the present petitioner, Milords. AD returned after valid service on
What
OP.
is this order 13/2/2023?
Milords, this is the order. Milords.
Come to page.
The discharge petition filed by the petitioner was rejected, Milords, after which we come.
That day.
No. The registries assume we have come against the order framing charge, Milords. That's not the case. We have come against the order rejecting discharge, Milords. That is.
Yes. Yeah, we have.
Another chance may be given while since
There
notice.
is no overtake attributed to the petitioner. He submits that if the allegation is FIR and the charge sheet is taken at its face value, there is no case made out. Therefore, the petitioner's case is squarely covered by the judgment of Vajan Lal so its notice of opposite party. Where is opposite party? Who is appearing?
Milords.
Who is appearing for opposite party number 2?
Milords, notice is sufficient. Milords, may kindly see the noting. I'll read the noting, Milords. AD returned after valid service.
Given since notice sufficient, Milord.
Notice is sufficient, Milords.
It's correct there.
If appear on that, it also.
Go 1 week. See, on 11/1/2024, notice was issued to opposite party
Number 2.
The stamp reporter's report indicate that the notice is sufficient. Notice is sufficient. However, there is However, there is no appearance on behalf of opposite party number 2. Mr. Ragada, appearing for the state, submits that one more opportunity should be given to the opposite party to appear before the court. The matter is accordingly adjourned for 1 week. And to
Milords, may kindly fix it.
come up on 8th, 9th के ऊपर
Milords,
13.
13 February, Milords.
Solicitor cause कर दो.
Again.
I may not be interested.
My name may be reflected in the order. Milords.
Name. He is a lawyer, practicing lawyer.
Yes, Milords.
Was it?
60-year-old lawyer, Milords.
Was it?
Again.
And the cost commensurate to his standing in the bar.
Milords. Milords.
Okay.
I'm grateful, Milords.
Yes.
Challenge the order dated 26/4/2023, but the petition has been filed by the petitioner without the compliance of the order that the earlier direction has been issued for 4,000 interim maintenance. But that has been rejected by the learned JMFC Patamudi, my lord.
What is it? Rejected?
Rejected on the ground that in absence of the petitioner and the respondent, my lord. The earlier he has filed a petition under section 12 and 18 of the 20 of the Domestic Violence Act, where interim maintenance was granted 4,000 per month to the petition number 1 and 2. Thereafter, they have not paid that amount. He has filed a petition before the very same court for compliance with the order. That has been rejected by the court.
That is 26/4, huh?
My lord.
The case record is put up today for hearing. Hearing on the petition also filed by the original petitioner and respondent to this case and found the petitioner filed Ajira, no taken on the respondent on repeated call of court, neither the parties have prepared to the petition for hearing. I put up the letter hearing on both the petitioner, the parties are directed to come ready for hearing. What is this? This order is nothing. You don't appear, nothing. What is it?
Each and every day the present petition was
See, read
appearing
the order,
to-
in order.
Yes, but I have gone through that order, man. I have gone through that order.
What indulgence you want? You moved the application. None of you are appearing. What?
That is my instruction is that each and every day you are
You have
attending the court.
instruction. I am not worried. The judicial order is there. You have not appeared on your own application, and you want 482 court to involve.
On each and every date, but he has filed the Hajira and he
Shall
was
I
present.
believe oral
Because
statement
Hajira-
of a lawyer on instruction, or shall I believe the court which records the order?
No, that is true, my lord.
Read the
Because
order.
It has been written, my lord.
Read the order.
He has.
Read the order.
Yes, record is put up today. I am reading for hearing on
The
petition
case
dated-
record put up
filed
today
by the
for
ordinary
hearing
petitioner
on the
respondent.
petition
Yes.
dated so and so,
Petitioner
filed by the
files
original
Hajira.
petitioner and respondent to
Petitioner
the
files
case.
Hajira.
Land counsel for the petitioner files Hajira.
Yes.
No step is taken on behalf of the respondent. On repeated call on the open court, neither the parties are appeared to move the petition for hearing. However, put up letter for hearing on both the petition. The parties are directed to come ready for hearing on the petition dated so and so, so and so. You are challenging this order in 482?
No, yes, my lord, I am challenged because I have filed the Hajira. I was very much present. And the council, he did not.
I will have to believe the judicial officer.
Well,
I will not believe.
Lordship fixed a date there so that on that date, it should happen on that date, it will be hard.
What is this 482? Don't misuse 482 like this, sir.
They have, the petition has filed the Hajira and although she was
You
present.
show me any application you have moved saying that yes, I was present in the court, it's wrongly recorded. Correct this proceeding.
Files Hajira means she was present.
Then you file the Hajira through someone and don't appear. How will I
No,
know?
the council is engaged, my lord. The council has not attended. That's what
Say
which issue has
he
come.
is calling repeatedly in the open court.
Yes, yes,
Nobody
no, that is
goes.
written there. I am not.
File Hajira through the clerk also. You send
So,
a
may I submit my lord?
slip through
Yes,
your clerk
destitute-
and don't come.
Destitute lady, you lordship fix a date there so that on that date it will be.
No, I will not do. Either you withdraw or I'll dismiss with cost. Decide.
That is the option for me to withdraw, my lord. Only the destitute lady, you lordship
Better,
can
sir,
consider
you
the.
withdraw because 482s are not meant for like this. The 482 jurisdiction is a little serious jurisdiction, you know. You can't file Hajira, you don't go to the court, then you complain against the judicial officer saying
what-
that I was there and he is passing this order.
He
What
has
is this?
engaged a lawyer, madam.
This is a poor reflection on the system.
He has engaged a lawyer and they have filed a Hazira, but because of the fault of
This
the
is a
lawyer.
complaint against, this is a complaint against the officer, JMFC. That despite the fact that you are present, he is recording like this.
How can I suggest for that?
I should believe it this is a serious allegation against an judicial officer. What are you saying? He's saying that open court he is calling and nobody is appearing. And he gave an opportunity to you also.
Because only
come ready with
I am not saying.
What else,
I am not.
He has not
attacking
passed any order against you. He only says that since nobody has appeared, parties are directed to come ready for hearing on the petition dated 15 to 2022 and 8 to he has not passed any order against you. You are saying that I was present and this order was passed. How can I interfere? If I interfere, it is a poor reflection.
No,
on
only
the
observation that petition will file a petition that will be taken into consideration.
You do whatever.
Yes.
I don't know.
That observation can be
Dismiss as withdrawn. No, I will not. Sorry, sir. I'm very. This is a poor reflection.
42.
Withdraw it. That's not dismiss. Simply withdraw. I will not say dismiss as withdrawn. Simply withdrawn. Why to say dismiss? I will not say dismiss also. Simply withdraw. Then counsel for the petitioner submits prays to withdraw this petition to pursue his remedy available under law. You move application, say that's maybe wrong recording, whatever. You move an application saying that, see, I was present, Hajira was filed, but there is a wrong recording of proceeding. You please correct it, and I think any officer will do that.
Yes.
Yes.
42.
Visitors. Page 15. Due to non-appearance on the date of first appearance itself, NBW has been issued.
See, you are supposed to send your junior. Since you have come 1,000.
More money.
It is not expected from you to come.
My associates are, because today is 30th. Here, why I am saying so?
30th is so speak.
No. Judgments are supposed to be delivered. Arguments, notes has to be given. In the civil and trial court, your lordship knows more. So 3 of my associates are busy in giving notes and adjusting to the court.
Still you should have sent in the evening. 1,000, huh? 1,000 plus. So why are you bargaining risk of heavier cost of coming? The seniors will come and do this matter.
This is the only source through which we can enrich our bar. How can
My lord, may kindly see the last order passed by your lordship.
Yes. Yes.
That matter your lordship had heard where a complaint case was filed. Thereafter, there was a civil suit. Civil suit compromise decree was passed. And now the complainant is not turning up in spite of notice because she had left the premises. Your lordship had directed the IO to serve the notice.
Yes, yes.
My lord, IO.
Yes.
ଆପଣ ବିଦେଶ ମୁତାବକ ସମନ୍ୱୟକୁ ନେଇ ଉକ୍ତ ପରିସର ମଧ୍ୟରେ ଅନେକ ପଚାରି ବୁଝିଲି କିନ୍ତୁ ପ୍ରତିଭା ଦାସ ନାମକ ବ୍ୟକ୍ତି ପରିଚୟ କେହି ଦେଇପାରିଲେ ରହୁଛି.
She has left the premise because she has got the fruits of the decree. The decree is now in her favor. In the compromise, she has got the decree. Now this Damoclean sword is hanging on me for a criminal case.
$498.
Yes, no, my lord. Not 498.
That is 490,
463, 464, 467, 184.
Okay. What is the allegation you have?
I cheated the allegation. Your lordship will see the FIR, the 1cc case at page 11. These are the offense against me.
Right. What is the allegation? 9.
The complainant shifted to Bhubaneswar permanently to address and resided there on dated 8. The complainant and her husband had been to purchase land from Patrapura in order to make a house building for making construction of the same. While the complainant and the husband were over the case land taking thinking about construction at that time, 5 young persons came and asked them about both of the.
You are the developer.
No, no.
You are the owner.
I was the owner, one owner.
Huh.
They claimed to have purchased the property to power company. And thereafter, there was a suit between the parties. She also claimed that the portion of the land, I also claimed that the owner is somebody else. We are both purchasers. There was a dispute regarding the purchase. Ultimately, a suit was filed by the complainant, that is civil suit number 27 of 2016.
And it is compromise.
It's a compromise decree passed, she has relinquished, she has taken money, everything is
He
okay.
relinquished in your favor.
Yes,
And took the money.
took the money and everything, the compromise decree was accordingly passed. Due to this 1cc case, which is now city case number 1556 of 15, but I am in the suit. Now she is.
Where
not-
is, let us read the compromise.
Yes.
The case record is put up before the
Yeah,
Lok Adalat
document
for
I will see
consideration
page
of
45.
petition. I am reading it. 39, page 39.
Page
Both the parties, the counsel
55
for
is
both
the
the parties
compromise.
are present. Heard the counsel for both the parties on the compromise, point of compromise, perused the record, verified the suit documents on the consideration. Hearing the compromise being appeared before the lawful is accepted, the compromise petition is allowed, and the suit is decreed in terms of the compromise and compromise petition to do the part of the decree. Which one you are reading? What is the compromise?
Madam, page 45.
45. 45, yes. Order 23.
Order
You move-
23.
Okay. Very, does it say that you will withdraw and?
No, madam, it was
having
not there.
purchased the
That
suit?
was not there. That was
The
not there.
concerned Tahsildar out of file verification title from the out of Pata number so and so, so and so. The Abhinav Mukherjee is in a fraudulent and slanderous manner managed to obtain.
Your lordship will see ground number 8.
So.
Without prejudice to the claim of the plaintiff, Amitabh Mukherjee, the so-called general power of attorney holder, the plaintiff herewith agreed and acknowledged by virtue of the compromise petition, she relinquished her right, title and interest over the suit land in favor of defendant Pradipta Kumar Mishra. The plaintiff acknowledged receipt of rupees 20 lakhs to demand draft in lieu of relinquishment.
Hey,
of-
defendant is Pradipta Kumar Mishra.
Yes, defendant is Pradipta Kumar Mishra.
But this complainant is someone else.
No, complainant is Pratibha Das.
Pratibha Das.
Yes.
Then
And I was a party minor. Hemanta Kumar Sahu, Prakash Chandra Jena, Amresh Barik and Pradipta Mishra, all were defendants. Before your lordship,
who was the plaintiff there?
plaintiff was Pratibha Das
Is Pratibha
Page
Das.
30.
Yes, Pratibha Das.
and complainant
45, page
Yes.
45 at the top.
and complainant is also Pratibha Das.
Who is Pradipta Kumar Mishra?
Pradipta Kumar Mishra, again, in whose favor the relinquishment deed was made. And we are the person they say we have cheated and in the sale. So she relinquished her say, took 20 lakhs from the Pradipta Mishra and forgone her right. So now neither Pratibha Das is agreed nor Pradipta Mishra is agreed.
Because Pradipta Mishra got the property,
Got the property.
full relinquish property.
And we are the persons who were in between, who are now in the suit.
Okay. Yes, Mr. Raghuda.
Madam, case is not with me, my lord. Perhaps this type of cases are civil in nature. The investigation must have been closed, my lord.
No, investigation has not been closed because as the complainant is not turning up.
Let us see what
Take
is
instruction to that effect, my lord. Whether the
You come to tomorrow, day after.
Day after.
Day after.
Next to the test.
No, keep it on 12th.
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 My lord, 12th.
My lord, it can be on second.
No,
day. What
not
tell-
12th, not 12th, 9th.
Record as
9th, Friday. 9th.
Second, they can also just they will ask whether the charge sheet has been filed or not.
Let us see what it appears. It can be
That's
quite.
ended with perhaps my lord.
Maybe.
No, it has
Then-
not been ended with closure report.
Take it,
Because the reason is, my lord, as the complainant is not turning up.
See, don't say all these things because your client knows more than the police knows it. That means you are habitual. So let us understand.
Yes.
You get 9th, you come and tell me.
In fact,
We will quash it accordingly.
your lordship did not grant me interim order due to my averment made in paragraph 3
Yes.
that the investigation is going on and charge sheet.
So
is
let
not-
us see.
Yes.
Oh.
Seeing this,
See, but she is not appearing. Apparently, she has taken money. She has no interest. Police might have got that information. Is keeping quiet. They may close it also. But if they close it, I'll record the statement and finish. If not, I'll quash it. 9.
Civil nature.
9. It is a civil nature, complete civil nature. We'll quash it. Okay.
44.
9th, huh? 9th.
Madam.
May I please your lordship?
Can it be on 8th, madam?
He may not get time.
8 ରେ ଆସିବନି ରଗଡ
Lord, prayer for quashing of the proceeding on the ground that matter has been amicably settled, And I have added the opposite parties number 2 and 3.
Notice has gone.
No, first time it has gone.
The counsel for the petitioner submits that he has entered into settlement with the opposite party number, party number 2 and 3. Who is the informant?
That bank,
Opposite party number 2 and 3. The opposite parties are the officers of the State Bank of India in India. The dispute is between the bank and the petitioner.
Yes,
petitioner. Since the parties have now settled the dispute, this court since the parties have now dispute, issue notice to the opposite party
2 and 3 by speed post.
And so requisite to be filed within
Within 2 days.
next week they
Yes.
and देखो opposite party number 2 and 3 may appear before the joint affidavit file करो.
No, John, the bank, they separate, they will file separate.
The opposite party number 2 and 3 may appear before this court on the next date appearing through virtual mode.
45.
May it please, your lordship. My lord, here also the petitioner prefer 167 subsection 2 application before the learned court below, my lord.
The same story.
But my lord, in this case, your lordship directed the learned counsel for the
1 minute, hold on. Yes.
Not a single reverse fund arguing in one case, my lord. Article 13, my lord. That has been adjourned to 20.
20?
20th to 40. Do better, my lord, that time.
Yes, 20th, because Mr. Devashish Panda has argued this point very elaborately. That is coming up on 20th. So let this matter be also be taken up on 20th. You may get benefit out. Okay? 20th. Yes.
20th February, your lordship.
Yes, it's 20th February.
Along with that case,
20th. Yes.
May I please your lordship? And the petitioner, in this case, petitioner has challenged the annexure to questioning of NVW.
45?
46.
Yes.
Questioning of NVW, right? Annexure 2, my lord.
Yes.
And the petitioner is a...
You are on bail from?
No, my lord. Questioning of abscond warrant has been issued. Abscond warrant has been issued. NVW.
you are the absconder.
Abscond.
I prayed for introduce. There are charges submitted. It did not appear again. And
When will you appear?
Surrender and release.
You surrender?
By next.
Who stops you? Any day?
Next.
Tomorrow? You surrender?
Next week. Then next week.
he is not never on bail, my lord.
It is,
No. 1 week I'll give. Let him surrender and take bail. Appropriate. The court will decide. Subject to why? When the affair? For 2014.
My lord.
When the NBW?
Charges 115 NVW issued, my lord. In the
2015.
And that is that NVW.
How many of you are there?
Charges submitted against some persons, my lord. But this man is the abscond.
Petitioner has no knowledge about the occurrence. Occurrence took place, but due to the political enmity, he tagged with this case. Petitioner is
an accused. In the FIR number, page 6, FIR number so and so. Full stop. After investigation, the police have filed charge sheet against other co-accused persons. but the present petitioner has absconded.
Not absconded.
And did not cooperate with the investigation. Full stop. Therefore, the police has moved an application for issuance of NBW against the petitioner. Accordingly, the Learned Trial Court issued NBW against the petitioner while its order dated
9/2/2015. 9/2/15.
2015. The petitioner is agreed by the said order. Agreed by the said order. Full stop. The petitioner, the counsel for the petitioner on instruction undertakes that the petitioner would be appearing, surrendering before the court below on or before 20th of February and avail remedy under law. Avail remedy under law. Subject to the said condition, the order dated 9/2/2015 is set aside. Passed by so and so is set aside. The petitioner is liable to pay cost of ₹1,000 to the welfare fund of so and so. You appear and get the pay.
Hon'Ble.
47.
May I please, Your Lordship?
The order of cognizance is under challenge. The petitioner number 1 is the husband of the opposite party number 2, and all other petitioners are in-laws.
Petition number 1 is
the husband of the opposite party number 2, my lord.
Yes.
Who is the
Kishore
Kumar Bodhai, and opposite party number 2, Sunita Bodhai, is the wife of the petitioner.
Rudra Narayan is the father, the brother.
My lord.
And Dileshwar is the father.
My lord.
And Santoshini
is the wife of Rudra Narayan Bodhai, my lord.
Petitioner 2. Yes. Tell me what happened.
My lord. So, affair was lodged
498 and all.
498A, 494, 34 of IPC,
Yes,
read
yes.
with section 4 of DP Act.
Yes, yes. You tell me. Why should it be quashed?
My lord, the marriage was solemnized in the year 2009, my lord. 1911-2009. Marriage was solemnized between the petitioner number 1 and the opposite party number 2. 8 years after, that is in the year 2017, wife lodged an affair in the police station, alleging therein that the petitioner number 1 and her all other in-laws subjected her to torture, humiliation, cruelty, so on and so forth, my lord. And so far as 494 is concerned, after conclusion of the investigation, charge sheet was submitted. Charge sheet has been submitted under section only 498A and 34 and 4 DP Act, my lord. May I submit, my lord, there is a possibility of reunion between the parties. But the parents of the opposite party number 2, the wife of the petitioner number 1, my lord, poisoning her mind. Therefore,
Therefore, the petitioner has filed this petition seeking indulgence of the court under section 482 CRPC, for quashing of the FIR number so and so under section so and so. The petitioners are the petitioner number 1 is the husband of opposite party number 2, whereas the other petitioners are the family member of petitioners number 1. Let counsel for the petitioner counsel for the petitioner submits at the outset that there is a fair possibility of settlement in this matter, barring the fact that the in-laws of opposite party, in-laws of petitioner number 1 are stumbling block stumbling block.
opposite party number 1, man.
Stumbling block. Next paragraph. Issue notice to opposite party number 1, written within 2 weeks. ठीक है, 2 weeks और date will be 2 weeks.
My lord, further proceeding.
Since next paragraph, since
Notice to opposite 2, my lord.
Opposite but not two.
since next paragraph, IA number लिख देवे 3074 of 2023. Since there is a fair possibility of settlement, settlement and non-issuance of fair possibility of the further since there is a fair possibility of settlement, further precipitation of the situation may hamper the possibility of settlement. So therefore, it would be expedient to pass interim order staying the further proceeding in the further proceeding in the further proceeding pending before the court of senior civil judge, so and so, you take it from the application, so. Further proceeding till the next date appearing. Next date appearing, don't come and file the requisites today only. Because the problem is once stay is granted, you will not file requisites, you will never serve, and this will go on and on.
A case of
My lord, within a period of 2 working days, my lord.
Within the period of 2 weeks, requisites
2 working days.
Make it to the
Tomorrow and the day after.
further proceeding is stay till you write the date. Write the date. Next date. 21st February. 48. If you don't do anything on 21st February, I will vacate this thing.
No, more.
As simple as that.
I will file a requisites within 2 days.
Yes. 48.
May I please, your lordship? Yes, your lordship can peruse page 18, order dated 9/2/2023. As per the prayer of the IO, NBW has been issued. It was beyond the knowledge of the petitioner.
NBW.
Yes, my lord. As per the before filing of the charge sheet.
Okay, you want a cancellation of NBW?
My lord.
When you got the bail?
I have not got the bill because it was beyond the knowledge of the.
Earlier case.
It was
He has absconded, charge sheet submitted.
not absconded. I have no knowledge, but because I filed the.
Okay, but you were absconded.
On 9/8/2023, it was been.
Petitioner is facing, petitioner is an accused in the FIR number so and so, page 13. After investigation, police has filed charge sheet against other accused persons, co-accused persons. However, the petitioner, co-accused person, since the petitioner was absconding, the charge sheet was filed, and the IO moved an application before the trial court for issuance of NBW.
Prior to charge sheet, my lord.
Prior to filing the charge sheet.
Since the petitioner was absconding,
During course of investigation, IO prior.
during the course of investigation, the IO had moved an application for issuance of a NBW.
Yes, madam.
The London trial court, by the order dated
9/2/2023.
9/2/2023, had issued NBW against the petitioner, and charge sheet has been filed.
My lord.
25/4/2023.
Subsequently, charge sheet has been filed against the other co-accused person on
25/4/2023.
25/4/2023. Also, the petitioner is now challenging the order order dated 9/2/2023 passed by the land trial court issuing NBW. Also, the land counsel for the petitioner on instruction submits that he would surrender before the court below on or before 20th of February and seek the remedy available to him under law. On the basis of this undertaking, the NBW issued by the trial court on 9/2/2023 is set aside, subject to the petitioner paying a cost of ₹1,000 to welfare fund of sorts.
Anticipatory here. Equal to anticipatory bail.
No, not anticipatory bail.
Well,
where is bail? I am not giving bail. You correct me if you are.
Well, 307 is there, my lord. Here is charge sheet.
307 is not my doubt.
NBW is issued earlier my enforcement investigation.
I have stayed it and he has to surrender and get the bail, regular bail. Do you need me to correct it? I
No,
will
no.
not do that.
No.
Any correction in
No.
the wording?
No.
307 has
You
nothing.
suggest,
Only 307 is there for that.
NBW shall be stayed for a period of that within that since that.
The operation of the order dated, operation of order dated 9/2/2023 is stayed till 20th of February. Till 20th of February, subject to condition that the petitioner surrenders before the court and avail remedy under law. Under law. And the said order is subject to subject to the cost of
May I pray one thing? 307 is there. 307 is not material. Where is the charge sheet? Where the charge sheet is there? The injury is in simple nature and it is, you will not may not be considered as an you will also kind only one line you shall be released.
Save your energy, argue all these things before trial court. If you satisfy the trial court, you will get the bail. Otherwise, no. You surrender before that. That's all. 10. The NBW state, for the operation of NBW state, जाहिर absconding price ना, state till so to surrender before the court and declaration. Yes.
49.
Yes, my lord. I am in the BC, my lord. This filed this application and there was defect in SR, my lord. Item 8, 13 and 20. They have to be removed, my lord.
Sorry?
Removal of defect, my lord. 8, 13, 20. It is a case, my lord, where the petitioner was in a cumulative loaded truck, my lord.
No, I'm sorry, I am not able to follow you.
My lord, I am challenging the institution of the FIR, my lord, against this petitioner. Because for one cause of action, there was two cases raised, my lord. One is a forest case, another is a police case, my lord. And in the forest case, my lord, first of all, my lord, the forester of Kenduja has seen the loaded truck wherein the petitioner was there. Petitioner is neither the owner of the truck nor the owner of the Kenduli. Accordingly, the case has been registered under the 14 Kenduli Act and PR has been submitted before the learned GMFC Kenduja. And the learned GMFC Kenduja, after trial concluded that, come to finding that the person is innocent and he has been acquitted in that case. Second, then, my lord, what the police has done, this forester is lodged an FIR before the police. That the truck was a thing to take.
Same issues, same application has been raised before this honorable court in CRLMC number 2908 of 2010, which has been disposed upon 25/6/2019, giving liberty to raise all these points at this time of charge. And again, this same application.
No, it is not the same. Your lordship will return to next state. I will satisfy my file is at cutoff. I am in the Sambalpur, my lord, in my residence.
Has he disclosed it?
He disclosed.
Yes, I remember, my lord. I disclosed. That number I will disclose.
Issue sir. No changes.
Is he not, sir? I am challenging in another issue. Another issue I am challenging.
Your lordship may kindly see the order.
Where is that order? Show me that order.
Say order.
Yes, yes, my lord, this
2908 of
2908 of 2000.
Exactly say.
Same.
Elaborately. Same thing.
You have approached this court by filing another CRLMC in the year 2010.
Yes, my lord.
This has been disposed of on 25/6/2019.
Yes, my lord. I am not complaining, my lord. Yes.
You have been given liberty to go to the court below and argue all this.
My humble submission.
Why have you repeated the same petition once again?
This is not repeatation, my lord. Lordship will adjourn to next week, my lord. I am satisfied because my file is at cutoff. I am at Sambalpur, my lord. Therefore, I am not avoiding the file, my. Therefore, exactly I can submit.
Next week, sir.
Next week, sir. Oh, yes. Next week. Let it go on the next week, my lord. Yes.
Item 50.
Item 50, I may, my lord, kindly taken up after launch.
Before lunch is not
Mr.
auspicious.
Mahanti, report number 3.
Okay, pass over.
Pass over.
Yes, 51.
51.
51 may I please? Only for 2 weeks time, Military.
Why 2 weeks time?
2 weeks time, Military. Prefer an adjournment, Military.
Adjourn.
52.
Obliged.
Yes. 52.
Behalf of Acharya, I may be qualified to argue.
Sorry?
On behalf of.
It's all right. You tell.
Here I am challenging the entire FIR, which has been registered under section 420-34 IPC. After investigation,
Charge sheet has been filed.
charge sheet has been filed.
Then
By adding section 4 of Prevention of Money Laundering Act and section 4(5) of Price and Cheats Money Act.
what are the grounds?
Grounds are that the IO is not confident to file the.
Yes, this I think this matter came up for.
Yes, one matter is there, but my learned senior is
Yes,
appearing.
Mr. Agarwal,
He
but
should have been.
I have not received copy. I have no idea about my friend.
He should have made the party.
And I think in this
IO has
case,
submitted.
I have also, we are also not made party also here.
PMLA Act.
PMLA Act ଅଛି ନା?
No,
add କରାହେଲା।
what he says is that the local police can't investigate and include PMLA. There is a bar.
That's correct.
These two sections are added now.
Police cannot.
So what to do?
Police cannot, that stage will not, I cannot
Hey,
say.
How will you justify?
That is the law.
Only when the, yes,
Police is
only
to
when
forward
the,
it to the, our department, they
That's-
cannot.
if
friend-
that is not there in the penal code.
No, initial FIR is all right. After charge sheet, if you find that the PMLA is attracted, and you should have involved that.
No. If that is exclusively tribal by the Court of Prevention of Money Laundering Act, exactly on the same offense, apart from the Indian Penal Code, then police has a duty to inform the. Then now.
But you have filed the charge sheet under
Yes, it is 420,
PMLA.
420 is there. Indian Penal Code is
No,
there.
420 no problem. You proceed 420 whatever. But in so far as the PMLA and call, it has to be cost.
The police has power to.
Incompetency. You should have involved them. Even if it is cost, that is at their liberty. They can start.
Yes.
They can start. Nobody can stop.
Yes.
The only technically you will win. Now you face 2 cases.
Yes.
Try to appreciate. If
Yes,
I
I
was,
will
then Mr. Agarwal is watching at you.
Yes, I will take
He
it,
will
sir.
swing his action against you. Now state case as well as another case.
I cannot, will not, unless the police forwarders.
They will forward it. I will watch it, they will forward it.
Yes.
He will have to face 2 cases then.
Then we, yeah, then he has to face.
Yes.
2 cases. It is better that you face now and get an acquittal.
No, that will face in special court for which.
You love that court, then you want to go. It's all
Yes.
right.
See, section 45.
I know that 45. and that-
Not
There
that,
is a bar,
notwithstanding
complete-
anything contained in the code or any other provision of this act, no police officer shall investigate into an offence under this act. Unless specifically.
You have not only done, you have investigated and filed the charge.
Whether authorized or not.
No, you should not have investigated.
If the authorized.
Authorized, then 43 or 44 something. is there.
45 subclass 2.
That is authorized.
ଯଦି ଅଥରାଇଜ ହେଇଥିବେ I will take instruction.
ପଚାରନ୍ତୁ authorized ହେଇଛନ୍ତି। ଯଦି authorized ହେଇଛନ୍ତି, that's a different story.
ଦେଖନ୍ତୁ ପଚାର।
Issue notice.
Yes.
Notice returnable within 2 weeks. Otherwise, these 3 provisions have to be quashed and you.
Yes.
Okay.
Yes. Yes, sorry, was I, Lordships in the middle of the matter? No.
Oh, sorry.
I'm sorry, I'm pardon to mention, my lords.
Yes, sir.
Item 2, which was passed over, my
Yeah,
lords.
yeah, we'll take it up.
My lords, I just want to withdraw the application.
You want to withdraw?
Yes, my lords, with an observation that because the trial court has already allowed my application under 317. By some misunderstanding, this application was filed.
I won't say anything. You can.
Without, if your lordship just observes it, that it will be beneficial for us in the trial.
Mr. Milan Karango, appearing for the item 2, appearing for the petitioner, seeks to withdraw this petition owing to the fact that his client's application under 317 has now been allowed.
Has been allowed.
Has been allowed. And the petition is allowed to be withdrawn. I am not saying dismiss or anything.
Deeply opposed. Item 17.
Yesterday's your lordship's direction has been complied with.
Yes.
The principal has also accepted the unconditional apology. They have complied your lordship's order in true letter and spirit. And the top apology accepted. At the top, your lordship will see the principal has signed the apology accepted.
Take it out. Yesterday, the matter was taken up for hearing. The following order was passed. Para 2, all para 2, 3. In compliance with the aforementioned order, the petitioners have personally visited the office of the opposite party number 2 and tendered a written apology and sought pardon from him for having sought pardon from him. The written apology tendered by the petitioner has been accepted by the opposite party number 2. Opposite party number 2. Opposite next party. Petitioners. Opposite party number 2. Accepted by opposite party number 2. Taking into consideration taking into consideration the aforementioned facts and submission at the bar, the FIR so and so submission bar and submission bar, the FIR number so and so, and the consequential proceeding. They are from Quas.
GR case number is 1210 of 11 and Malgodam PS case number 91 of 11. Pending in the court of JMFC 3 Cuttack.
JMFC 3 Cuttack. Because subject to the petitioner's paying.
I leave it to your lordship. There is no bargain on that. But we are young counsels. He has complied.
1,000 each.
Yes,
Mr.
Bose only.
You bear it.
Yes, Mr. Bose will bear.
I am more poorer than him. I am doing it pro bono. They are my associates.
And everybody knows what you are. Don't say that. Pay 1,000, but don't ask them. You have to pay.
1,500 each, your lordship.
Don't have. What is it?
All right.
You are bargaining. You paid. Okay.
1,000 to
1,000 each to High Court Bar.
Advocates Welfare Fund.
That goes to that fund only.
Great fund.
63, there is a personal appearance. Let us take it.
63.
Who is appearing?
Yes, well, OP2 victim.
What is the case? 63, let us see. Washing?
Yes, my lord. 506 363 34 IPC. In the meantime, they are married and one daughter girl was.
Pokso to nahi?
No, no.
The petitioners, who is the petitioner? Petitioner is Sadananda Molo. And Snigdharani Mol is the wife.
Yes.
FIR informant is Snigdharani.
Father. Opposite party number 1.
Opposite party number 1.
Not 2 again.
Damodar Rao.
My lord,
Opposite party number 3 then.
my lord.
Huh? Opposite party
Father.
number 3 is there.
Father.
Who is the informant? Father. Where is the informant?
Directed
to OP number 2 appear, so I am appealing.
अरे informant
अरे informant तो आनियो भाई. What is this? You want passing of the FIR and you don't have informant.
अरे informant हो
And tomorrow he'll say that it is my FIR and you.
अरे दामोदर को डाको दामोदर.
Can you call? I will wait. Where is he?
Denkanana.
They are living together. Father with the FIR.
What is the FIR? FIR? What are the provisions?
Page 9 FIR.
See, that's the problem. What to do?
Father ଟା ଆସିବା ଦରକାର କାହିଁ informant ନାହିଁ.
Informant ନଥିଲେ କେମିତି କ୍ୱାସ୍ କରୁ?
ଏମିତି ହେଇପାରିବନି. Without hearing the informant.
ବାପା ତ ଆସୁନି appeal କରୁ.
At least informant को notice ବରଂ ଯାओ.
Notice जाए.
Notice
जाए sufficient.
What is her age?
Now she is 26.
When the offense has taken place?
2015.
15. What was her age that time?
18 plus.
Just check it, Mr. Maharaj. We will pass it. Because ultimately they are saying there is a child also.
And 8 years daughter girl was there.
ସେଇ କିଛି ଏଜ୍ ଲେଖି ନାହାନ୍ତି +2 କଳା ଛାତ୍ରୀ.
We give the
+2 କଳା ଛାତ୍ରୀ ଲେଖା ହେଇଛି. No,
No, not affidavit. Give Aadhaar card.
already I am attached with that affidavit, my lord.
Just see, check it up. Give it to. I'll take it up just now. You see, let him check it.
Yes, sir.
Call seriously. Let him. 12. Urgent. ठीक है. Next.
Item 50.
50. Okay. Pass over.
Again passport, my lord.
Again pass over.
Madam, court number 6 is
Okay, okay. Who is appearing?
Madam, B.R. Mahanti, madam.
Mahanti.
Madam.
Vibhuranjan Mahanti.
Madam.
Okay. Next. 50.
53.
Again. May I please?
NVW has been issued on 4th May 2023.
4th May 2023. Bail?
Bail 25/8/2021.
21. 25/8.
Yes, madam.
Bail on 25/8/2021 and NBW 4/5/2023. Okay.
Yes.
He undertakes to appear before the court below.
Yes.
Court below, no?
Yes, ma'am.
Court below 20 before 1 hour before 20th of February and avail remedy under law. And 500.
500.
Oh, like, ma'am.
Cost 500.
54.
54.
May I please, your lordship, on behalf of Mr. Priyadan Singh, may I be permitted to submit, your lordship. Then the petition has paid for invoking your lordship's 482 jurisdiction of this this Hon'Ble court for quashing of the FIR, your lordship, criminal proceedings, your lordship. The petitions are the in-laws, your lordship. Petitioners are the elder brother-in-law and the sister, elder sister-in-law, and brother-in-law and sister-in-law. There is no allegation. It's all
Samal.
Yes.
Bonti Samal Harihar.
Madam.
Sila.
Sila.
Is the sister-in-law.
Petition number 1 is the elder brother-in-law. His wife is petition number 3 and sorry.
Now, what is the allegation?
Allegation is an all omnibus allegation, your lordship. So there's your lordship knows that FS court judgment. There's if the omnibus allegation.
They are on bail.
They are on bail, and my lord, the DV case has been decided, and husband has been paying the interim maintenance. There no chances of reunion because she is getting maintenance for the last so many.
So why don't you settle? Pay something. No union, reunion. Settle.
Well, she is getting patent. It's because the court below in the DV case, the court hold that she didn't issue a notice to the petitioners.
Okay, let us issue notice. Let us.
Yes, your lordship.
Issue notice to opposite party number 2, returnable within 2 weeks. Requisites you file. We'll see 2 weeks. Thereafter, just give. Which date you will give? You give 23rd. 23rd February.
My lord, sir, interim application is there for the step.
Issue notice on the interim application as well.
If they am covered by the your lordship judgment, there's a recent.
Right, I understand. We let her come. We'll do it. Nothing will happen. Yes, 63. Yes.
63.
17
Yes.
63 says you may kindly see the whether the notice has been sufficient to the informant.
Just see whether notice is sufficient.
Notice is sufficient.
The date has been given in this.
We given 23.
সেটাকে দেখি দেন সেই যে অবজারভেশনটা দিয়ে দেন notice service sufficient. You lost him that observe
that
even though the notice has been sufficient, but he is not
wide order dated yes. Yes, the matter was taken up for hearing on 8/1/2024, and this court has passed the following order. Order. Pursuant to the aforementioned order, the notice was issued to opposite party number 2. Although the notice has been validly served, but there is no appearance on behalf of the opposite party number 3. Sorry, opposite party number 3. Opposite party number 3. The petitioner and opposite party number 2 are present in the court, and they are being represented by the respective counsel and respective counsel. The counsel, the respective counsel, they are identified by their counsels. They have also filed the self-attested photocopy of the Aadhaar card to establish their identity. It is have they filed joint affidavit? No, joint affidavit. Today they have filed a joint affidavit. Joint affidavit inter alia stating that they have
separate OP number 2.
Separate. They have filed separate affidavits. Separate affidavits reiterating their stand.
OP2 has
fact of settlement.
may indicate OP2 has filed the affidavit.
They have appeared. That's what I think. The petitioner has not filed. Okay.
Petition
They have not filed. The opposite party number 2 has filed an affidavit inter alia stating that he was in relationship with the petitioner and subsequently they have married, and out of this wedlock there is a child.
Yes.
Therefore, she doesn't want to proceed against the petitioner. Full stop. Despite notice, the opposite party number 3, who is the father of the opposite party number 2, and the informant in the instant case has not appeared. Taking into consideration the fact that the parties are now, the petitioner and opposite party number 2 has now married and leading a happy marital life, no fruitful purpose would be served to proceed with this matter. Hence, the present petition is allowed, and the FIR number so and so and consequential proceeding arising therefrom are satisfied. Yes. 25.
May I please, my lord? I'm appearing to VC, my lords.
Yes.
This case was last listed on.
Let's check what is.
This case was last listed on 10th of January, my lords. Wherein your lord has passed an order to submit the sufficient stamps with requisites. We have submitted the requisites with the stamps.
Before also P2. It appears from example the petitioner has filed the requisite. Yes.
We have submitted.
Yes. Have you filed the
yes,
process?
Yes, my lords. Yes,
Here.
we have submitted on 24th of this month. The file receipt
Take it
number
up.
is 9877 of 24.
Awaiting. Item returned. Rajni report. Received. Item received लिखा है कोड लिखा है item ऊपर ना 27 वाला ना item yes. So now the service is complete, but nobody has appeared.
Lots.
So let us give one more opportunity, isn't it?
Yes.
As you lordship deem appropriate.
I will just re-notify the pursuant to the order of this court dated 7/12/2023 and 10/1/2024. The opposite party number 2, na? Opposite party number 2 was served. Opposite party number 2 and 3. 2 and 3.
Opposite party number 2 and 3.
I record the claim.
7/12 order ହେଇଥିଲା କିନ୍ତୁ ସେମାନେ requisites file କରିନଥିଲେ.
No, that no. 3. What is his name?
Viswanath Sikkim lots.
3 service exam. 2 da him. See, नहीं opposite party, although opposite party number 3 na 3 sir, 3 sir, but opposite party, the service on the opposite party number 2 is still awaiting. Crest tape durkar ki?
Crest tape is.
Crest tape durkar?
Press.
My lords,
Petitioners.
may I be allowed to submit, my lords?
Petitioners
May I
should
be allowed
take press tape to serve opposite party number 2. Returnable within 2 weeks. They get it.
Interim order till then, my lords.
Interim order to
Requisites ଟା ଆପଣ file କରିବେ.
Requisite file କରନ୍ତୁ.
My lords, may I be allowed to submit?
Only for 2. Only for 2. 3 has been served.
On 24th, we have submitted the requisites together with the stamp, my lords. On 24th.
Once again, insofar as opposite party number 2 is concerned, you take first steps.
Okay, fine.
Okay. Yes, next.
56.
Wait, please, your lordship. My lord, here the petitioner is an accused in a PMLA case, my lord. What has happened in the meantime, my lord? During the investigation, he has cooperated with the agency, has appeared before the agency, and ECR was filed in the year 2018. What has happened in the meantime, my lord? Your lordship may kindly see the impugned order at page 183. The relevant portion.
183.
Yes, my lord. Relevant portion at page 87.
Which annexure? That is 7.
Annexure 7, my lord.
Okay. Yes.
Which the impugned order, my lord. The operative portion is at page 187, my lord. Issue NBW against accused person by serial number 6 and 11, namely Sambit Kumar Khuntia and Rajat Chaudhary. Rajat Chaudhary is serial number 11, my lord. Put up on 2012-2023 for appearance of accused persons by so and so. Accused person serial number 6 and 11 and hearing on petition for accused number so and so. My lord, what I am praying, my ground is here, my lord. What has happened in the first instance itself, on the default of the accused or the lawyer, my lord, on the first instance, this NBW has been issued. I am relying upon one judgment of this honorable.
But I'm afraid whether I can hear this matter or not. Because for few accused at one point in time I appeared, but there are many cases of similar nature. I don't know whether in this case I appeared or I don't know.
My lord, this
is related to
a group, my lord.
there are many cases, no? But for few of the accused, for the few of the accused I have appeared in this court as well as in Supreme Court.
Oh, then you have also.
I am
Rajat Chaudhary, my lord.
Maybe he may, I have not appeared for him, but I have appeared for few of the accused here in this court as well as in Supreme Court. So it is not, and CBI cases also.
Then your lordship better not.
Better not to hear. Please, before some other bench where I am not a party, subject to the permission of the Honorable ACG.
Your lordship may indicate our appearance and my name may be appear.
Appearance, right, both the appearance.
Name may be indicated in the list also.
Huh?
Okay.
Because there are so many cases.
Yes, my lord.
We don't know.
There are number 26 accused persons are there.
That's right. So that. Yes. Bail, when you got the bail? Huh?
I was on bail lordship.
2000.
17/1/2019 ବେଲ୍ ଯାଇଥିଲି 17/5/2019 ୱାରେଣ୍ଟ ହେଲା
17/5/2019. That's the NBW.
Yes.
When you got the bail?
17/1/2019.
17/1/2019. He got bail and he did not appear, and so therefore the NBW on 17/5/500 set aside. And you appear before the court on or before 20th.
58.
1/11/2023 NBW was issued. You are granted bail by 25/11/2013.
25/11/2013 bail, and NBW is
1/11/2023.
1/11/2023.
No.
1/11/2023.
Page 10.
No steps is taken to take it. 1000? Senior, so many people.
Matrimonial.
Senior, so therefore it is double.
Senior.
You are senior. You are appearing. We look at your face, that's all. 500 each, because 1, 2, 3, 4. 500. No, 500 each. Give it to 500 each.
1000 जोटा କହିଥିଲେ ସେଟା ଥାଉ
1000 each.
ନା
Each. I thought one accused. There are 4 accused.
Matrimonial 490.
Therefore 2000. 2000.
1000.
Subject to payment of 1000.
I remember the proposal given by Mr. Maharaj. Next time I will.
You will not compensate. You will compensate.
59 May Lordship. In this case, I have already copy served. The deputy.
59.
Yes, Your Lordship.
Okay.
I have already copy served. I have the receipt, obtained the receipt. Here is the present petition challenging the entire initiation of the criminal proceeding for quashment on the grounds on the bare perusal of the.
What charge sheet has been filed?
Yes, Your Lordship. So for my instance, charge sheet is filed.
Charge sheet has been filed. You got the copies?
For the time being, I have not obtained the certificate of this charge sheet, copy of the charge sheet. But my instruction is the charge sheet is filed, Your Lordship.
Get the charge sheet. If you want to, you want cost.
My kindly glance the 15, the page 15, the.
Now what will I do? You are asking for quashing of FIR.
Yes, Your
Charge sheet has been filed. After investigation, what material has come against you? Has been seen?
Only offense is 306/34, Your Lordship. So for 306.
That was in FIR.
Yes, Your Lordship.
After investigation, what material has come? It may be some other offense. Who knows?
Then in the meantime, state has given 2 reference. One is ABL 115354/2020.
What happened to that?
It has been rejected, elaborately discussed everything, and it has been rejected on 13/10/2023.
Quashing only.
And again another ABL appeal have been filed. 12089/2023. It has been withdrawn on 9/11/2023.
You repeated attempt to get the bail.
No, I am not.
So therefore 482.
No, kindly glance for a moment, Your Lordship. The bare perusal of the affair. So for yes, sir, that part I have filed.
You could not convince the bail court. You want to convince the 482 court.
No, Your Lordship, that I am not saying, Your Lordship. My predicament is concerned. So far 306 is concerned, is not at all attracted super pension.
So that you attempted in 2 occasions before 2 courts, you could not.
persuade them.
Your Lordship, my predicament is concerned, Your Lordship, so far I am surrender and go and by Lordship, I face the trial. That outcome
The
of
same
trial.
thing you might have said there also. They might not have.
Your
heard
Lordship,
you.
for it in the inherent jurisdiction for the second ends of justice, Your Lordship
Inherent
can grant it.
jurisdiction doesn't mean that the coordinate bench order is also. I will.
I am not, I am here not is the, I am approaching under section 482, Your Lordship, not I am the 438, Your Lordship.
So therefore, simply dismissal is the best
Lordship,
relief without saying anything.
Kindly, Lordship, sir, for the Lordship, charge sheet for the charge sheet file, Your Lordship, for my charge sheet file. Your Lordship, let it be.
I'll record your statement that you will surrender and avail appropriate remedy under law.
Lordship, that might not be considered because 306.
What to do? There are two. You have not filed
Yes,
those.
Lordship,
Do you
kindly
have those orders?
Your Lordship, this case is clearly covered
You
by
have
the
the
judgment.
No, no, no.
Lordship, kindly glance for a moment, Your Lordship, Rukmani said versus State of Odisha. Similar circumstances. This honorable court has quashed the entire proceeding, Your Lordship.
You are not able to get
Yes,
bail
sir,
by the coordinate bench of
That
this
is Your
court.
Lordship. That difficulty is Your Lordship. For so far, for it is concerned, Your Lordship is having the inherent jurisdiction to quash Your Lordship. Lordship, that can you consider so far prisoner is concerned, Your Lordship.
I consider thereafter only I am saying.
Lordship, kindly glance. I am ready to surrender.
What to do? Do you have these orders?
Yes, Your Lordship.
Give me the.
Yes, Your Lordship.
No, no, no. These orders, bail orders. These are minimum. In fact, you are disclosing means you have to file those. also.
Yes, I have disclosed, Your Lordship. I have obtained one order, Lordship. So first,
One you have withdrawn.
yes, Your Lordship. Second,
The one is detail order. Where is that detail order?
detail order copy not with me for the time
one
being.
is detail order?
Let it to one pass over, Lordship.
Which one? No, 1115.
Is there that part?
That is a
That
detail
copy is not with me.
Take out an order. Take out. I'm just passing it over. Take out. Let me see.
Yes, Your Lordship. Sir, kindly glance one judgment, Your Lordship. Is the
I'll
Rukmani
have to see
requested?
that order only first.
Yes, Your Lordship.
Yes. Card print card. Take out the print. You don't have printer here. Printer you have. Take it out. Here. Next.
50 my
Pass it over.
50 password.
How this is happening? Sometime 59, some 50. Why passover you are not called? Then wait till the end. It's not that as and when you enter, your matter will be taken up. Other lawyers, senior lawyers are waiting. What is this practice? And why are you calling like this? Once it is passover, at the end. First passover before lunch will be at 2 o'clock, and next passover is at the end. Not that any lawyer will get inside the court and they will do it. The other senior lawyers are waiting. Follow some system. Don't convert it to a kacheri. This is a high court. Yes, next.
May I please, Lordships?
Lordship,
My lord,
filed a vacation, interim application for vacation of interim orders.
You have filed?
Yes.
Yes.
Here,
I am the petitioner. Let me.
the vacation order is pending. I'll start that way. If he wants, he can, but I should start because it's an interim application that is pending.
When was that order taken?
Yes, my lords. Means the order was passed on 19/5/2023.
Yes.
I filed an interim order. Now, my lords, what is the issue? Here, I am the complainant. They had taken 1 crore some odd as cash and in the form of.
But that interim order was till a particular date.
Yes.
That 31/7/2023.
That is being continued as of now.
Not continued, madam.
Okay.
That is no problem. That issue here is the interim order, my lord, sees para 3 of the interim order.
You are reading 19/5?
Yes.
Okay.
Mr. P.K. Deo, learned counsel for the petitioner, submits that the case is not maintainable as the power of attorney has not been executed in accordance with law and referring to section 143A of NI Act. He further submits that the petitioner has appeared in the case on 16/3/2022 and has been released on bail on the same day. And the decision of this court in Saroj Kumar Jaina versus Santanu Kumar Sahu, reported in 2022, 88 OCR 5353, submits that the state has not come for directing for deposit of 20% of the defaulted amount, but by order dated 23/11/2022, the Learned JMFC Chandikhol has directed the petitioner to pay an amount of ₹3 lakhs to the complainant within 60 days. He further submits that when the case is not maintainable, this order passed for deposit is uncalled for. Now, my lords, 4 grounds were taken in the petition. First ground, that the complainant is not duly authorized. Second, the partnership firm is not duly registered. Third, that the partnership firm, the person who has given the general power of attorney, he does not have the authority. It should have been signed by all partners. And fourth, that this amount that has been deposited, GPA not specifically providing for filing of application. Now I'll deal with the four grounds. I've taken grounds on my reply. I've also filed relied on the said grounds in my interim application for vacation of interim months. Now, I'll just, before I go there, I'll just I'll seek the liberty to place section 143A, because the whole gamut, the legal gamut is that 143A stays has reached for awarding interim compensation or not. So what 143A, I've given the liberty.
Yeah, I know, but read it.
Yes. Notwithstanding anything contained in the Code of Criminal Procedure 1973, the court trying an offence under section 138 may order drawer of the check to pay interim compensation to the claimant in a summary trial or a summons case where he pleads not guilty to the accusation made in the complaint. In any other case, upon framing, I'm not there. I'm on the point A, that there should be in a summary trial where he pleads not guilty. So in the present case, their whole accusation is that the stays has not come. Now, Milords, how a false statement was given to the court and the order was passed. Milords, I'll just point out that Milords goes to Milords, page.
No, what is your case? You tell.
Yes.
Why are you going to all these things?
No, Milords, I'll say so. They are saying that the stays has not come. I'll show from the documents.
What tell me why? What is the basis?
Yes, he's saying the stays has not come.
Complaint was filed.
Yes.
Someone has been done.
Yes.
Then case has come. As simple as that. Why?
Bail has been granted. He has pleaded not guilty.
On that date, on that date of bail, Milords.
He pleads not guilty.
Now what is the position? 20% you have to pay.
Yes.
Milords.
Are you paying or not? Simple.
No,
why are you going here and there?
No, Milords. I will submit one thing, Milords. Milords, in this case, Milord, what happened? Milords, the power of attorney holder has filed the case.
Those are merits. I am not on this.
No, Milords, the award is on 10%, Milord. The trial court has passed 10% interim compensation, Milords, under section 143A, Milords. The cognizance order, Milords, the person who has filed the complaint petition, Milords, he has not supported to file the power of attorney, not taken any averment, not has specifically taken that he has got personal knowledge or he has witnessed the transaction, everything, Milords. And on that score, Milords, I am submitting, Milords.
The moment you plead not guilty,
my lord,
and 143A comes into play, then you have to pay that
what happened in this case, Milord?
Then all these defenses are available to you.
Yes.
So you are crossing.
I'm obliged by that opinion. My lords, what happened in this case on the first day of my lord's appearance, on that date he has released on bail. What did, my lords? Thereafter, my lords,
138 summary trial, obviously bail.
on that date, my lords, when later on order was passed that he has pleaded not guilty and something or this on that date only, on the first date, my lords. No opportunity is given, nothing, my lords.
All these things.
And that about, my lords, the power of attorney holder, my lords, he has not filed the power of attorney before the London trial court. He has not taken any appointment as per my lords, the Supreme Court decision, my lords, I am submitting, my lord, may kindly peruse. He is not
Where is your notice under 138? Statutory notice.
That they had to file. They have not filed that.
I
have given.
You have issued notice.
That is not the issue. That is not the object. They have given that, my lords.
No, orders. I will show the orders. May I kindly see the decision.
What is the judgment?
What do you want? This out of this 2013.
2013.
Which paragraph and what is the proposition?
My lord, the paragraph 23 minutes.
No, what is the proposition?
My lord, the proposition is, my lords, the person, if he will file the complaint petition, my lords, he should have got direct knowledge and he must be the witness with the transaction.
and he must avert the averments in the complaint petition that he has got knowledge. Without that, my lord, he cannot examine under section 200 of CRPC.
Where is the order of 13/1/2022? Let's come to 13/1.
My lord.
My lords.
Yes, 14 minutes convenience order.
You have challenged that only the cognizance order, huh?
Cognizance, my lord.
He has challenged only cognizance order, not that 143A.
Lords, the challenge the recognition order, there is a stay on the
No, what he says, he try to understand. What he says is, why are you bringing 143?
Yes, my lords.
What he says, the cognizance is taken on a complaint, which is not competent complaint.
Yes, my
The
lords.
complaint itself was bad in law
Now, my lords,
because the person who has instituted the complaint is not a competent person.
Now, my lords, I'll prove that on the basis of his records. Not, I'll not go to my records. That I'm competent.
You are power of attorney holder.
Yes.
And you have given the affidavit. Let us see the affidavit.
Yes, my lords. Page 13 of the petition, my lords.
Well, the annexure 1 is the complaint petition, my lord.
Yes,
Annexure 1, page 13 of the petition, my lords.
13.
Name of the complainant is the Hotel Mid East.
Yes.
My lords.
And I have given a
Power of
verification
attorney holder.
and an affidavit.
Who, Sarath Kumar Rao,
Samal.
Samal is
Yes.
the owner.
No, it's a part of attorney holder. Now, the issue is that he is a general part of attorney holder. That issue that
Who has given power of attorney?
Yes, the managing partner. Now the judgment is to that regard, my lords, I have given a written note. On the last occasion, I had submitted a written note, my lords, of judgments. 4 judgments I'm relying on. I'm also relying on his judgment. Para 70.
The Hotel Mid East is a sole proprietorship company.
It's a partnership. Partnership firm.
And the one of the partners has given.
Managing partner. He has been authorized to that behalf by them in the registered partnership deed, my lords.
This is also my second point, my lords. The only one person he has given
Judgment, my
the
lords,
power of attorney, my
managing
lords.
partner can do it.
And no resolution on that.
The general power of attorney holder can do it. Judgments are there to the affidavit.
No, resolution
The partners are given my written note.
1 minute.
there is some resolution to that effect. And he has not filed any document with us before the law and trial book.
My lords,
Neither the power of attorney nor the resolution, my lords. And
Come to your affidavit, page 13.
Yes, my lords.
Read it out.
Yes, I, Sarath Kumar Samal, aged about 48 years, son of Prabhakar Samal, residing at Garagali.
Paragraph read.
Yes, my lord. I have not concealed any material facts. That the facts stated here and above, but
No, first paragraph.
First paragraph. I am the power of holder of the petitioner farm and hence.
Petitioner farm.
Yes, my lords.
Can a farm execute a power of attorney?
Yes, my lords. Answer is yes. The answer here is the judgment, my lords. A.C. Narayanan and others was the state of Maharashtra. My lords have given the written note.
A.C. Narayan, he is also relying upon.
My lords.
SBS, my lords.
Which paragraph you are relying and which
Para
paragraph?
21, 22, 23, 24 and 26.
So go slow, go slow.
Don't
get excited. Go slow.
Para number 21, my lords.
21. He is relying upon
23,
20. Let us see.
The power of attorney, may I please, my lord?
21. Okay.
Power of attorney holder is the agent of the grantor. When the grantor authorizes the power attorney holder to initiate legal proceedings and the attorney holder accordingly initiates such legal proceedings, he does so as the agent of the grantor, and the initiation is by the grantor represented by his by his attorney holder and not by attorney holder in his personal capacity. Therefore, where the payee is a proprietor concern, the complaint can be filed by the proprietor of the proprietary concern, describing himself as the sole proprietor of the payee. The proprietor is concerned, describing himself as the sole proprietor concern, represented by its sole proprietor.
That's why I am asking you, is it a proprietorship concern?
No, it's a
If it is a proprietorship concern, the proprietor can give power of attorney to prosecute the case.
Even partnership firm can do it.
Show me that judgment.
Yes, but this judgment. Here also it is written there, my lords.
It's a proprietorship concern.
Yes. Now from a conjoint, paragraph 22, my lords. Para 21 deals with proprietors with
From
concern.
the congent reading of section 138, 140 so,
Yes.
as well as section 200, it is clear open to magistrate to issue process, the basis of the contents of the complaint document supported thereof, the affidavit submitted by the complainant in support of the complainant. Once the complainant files the affidavit in support of the complaint before the issuance of the process under 200, and it is further open to the magistrate and the things will follow up examined from. However, in the matter of discretion, the magistrate is bound to call up with the complaint for the incident. What does it say? Nothing.
Now, paragraph 26 is the findings.
That's what he is also relying. Read it.
While holding that there is no serious conflict between the decisions in MMTC and Janki Vasudev Bhoswani, we clarify the position and answer the questions in the following. The filing of complaint under petition under section 138 of NI Act through power of attorney is perfectly legal and competent. Now, the power of attorney can depose and verify on oath before the court in order to prove the contents of the complaint. However, the power of attorney holder must have witnessed the transaction as an agent of the payee / holder in due course of or possess due knowledge regarding the said transaction. That I have given affidavit.
Show me in the averment that you have said that.
Yes.
Show me in the averment.
In the averment,
averment in the complaint.
Petition.
That you have seen it.
Because that is in the affidavit. The affidavit, I say, I am the power of attorney of the petitioner firm and hence swear this affidavit being well aware with the facts and circumstances of the case. Now, that is one. Let's say. Now, Milord said that where in the petition? In the petition that I have filed.
In the complaint, have you said that the entire transaction has taken place in my presence or I know this fact? Otherwise, you are hit by para 26. You are gone.
Milords. Now that, Milords, okay. Even if that Milords has understood, we're saying that.
No, even if you come.
Now, Milords, that judgment is answered in TRL Tosaki. That judgment, Milords, I think my written note is somewhere not there in front of me.
The written note here is filed.
Now, this is the most para page 22. Do you have a written?
Have you filed?
Yes.
Order,
on the last occasion,
order 37 suit.
Milords?
Have you filed order 37 suit? No.
No. That has not been filed. I understood.
Why don't you pay?
Well,
Instead of technically pay something.
Behind my one thing I will say. The entire allegation is 1,75 lakhs. And he has admitted in his petition 1,10 lakhs has been paid. He has admitted. This is the fact. Actually 1,10 lakhs was given. For that reason, check was given. After getting 1,10 lakhs, subsequently this check has been, my lord. This is the real situation, my lord. No, my lord, I am not arguing with you. This is the real situation.
Give me check. This is the amount I will pay you. He failed.
And I will show.
What was the due amount? Legally recoverable amount?
1,75.
175?
Yes.
You have taken 110?
I am sure of one. I don't know one. Anyway, that something is remaining. That I am sure of. 60 lakhs, 65 lakhs, he has given check.
Only 65 lakhs?
Yes.
No, 55 lakhs.
Check amount is, he said 120. What is the check amount? Let us see.
The 50 lakh we have, that's again the Kotte Dos Lakhs we have only placed
the complaint, my lord, they have avoided the complaint with sir. Annex 1 million.
Milords, he's correct. I agree with him. He's correct. 1 crore 55, 1 crore 10 can 50 lakh check logage. Had it been, I would have placed a 60 lakh check.
51 check amount is
58 payment back.
Check amount is 1 crore 75.
Yes.
No, Milords.
No, Milords. Entire allegation.
My lord, say
amount is 43 lakhs. 43 lakhs.
Yes.
Well, I will take instruction.
You pay.
Well, I will take instruction. Any date, my lord. Any date.
1 minute, I am trying to find out. Why are you so? And technically, you are out.
That judgment protects me of justice under
That judgment. Don't be so.
Okay,
I'm trying to find out a way, get the money and how much, when will you pay, how much?
I will pay, Milords.
Well,
I will pay 1 thing, Milords. My lord, if this case will
You owe
be.
the money, you have to pay.
No, no, so this case may be given to mediation center. Probably.
No, why
it will
it
be
is-
finalized.
no,
It will be finalized, my lord.
take your money,
It
okay.
will be finalized, my lord. Both are neighbor, my lord. Both are neighbor.
Neighbor,
Huh?
where are we neighbors? I stay in Cuttack. You stay in Chandigarh. We have
आप
50 kilometers
फंसे हैं।
neighboring.
चंडीगढ़ mediation
That
center सही है।
if he is agreeing, see, you have to receive the money,
हाँ
you
क्या?
have to pay the
तो
money.
पाइजे होता है।
Okay?
हाँ
The
क्या?
person who is ready to pay money,
Then let
he
him
is
go.
agreeing for mediation.
Can you
हाँ क्या?
give me a time limit that in this time limit I will pay.
तो minor it is, you will decide.
चौदह नहीं पाएगा मैं कौन दूँ
हाँ yeah, mediation bank बहुत
Go to mediation.
over anxious.
Try.
My lord.
You may get a better deal also.
My
And I will await the report and
yes, my lord.
Yeah, at least till that point, let him pay the interim compensation.
Sorry, sorry,
At least intend 10%.
that is not an issue here. He is challenging the cognizance order. Either I have to take a call.
Mediation
I'll
has
take the cognizance order. You want a judgment, then I'll see. And
You will be
okay.
You will either you.
And it is a risk you are bargaining. If I am agreeing, it's
Mediation
not right.
is
No, otherwise it is. Okay,
Aye.
you tell me. So
The three judgment, my lord.
yes, tell me.
So, Millards, para 7 Millards. There are 17 Millards.
17. Okay.
Yes, Millards. There is no bar on a power of attorney holder on representing a company unless they have been swear. If it is even swear in the affidavit.
It's a company again. First judgment you have shown proprietorship.
Yes.
It is a company. You are a partnership form. Where is the resolution? Show me.
And this
The
is
other
civil
partner has
dispute.
given you. Where is show me?
Again, ଗୋଟେ copy ଥିଲା, ଆଉ ଗୋଟେ copy ଦେଇଥିଲି. I'll give another.
Why are you unnecessary?
Okay, Millards.
Inviting a problem for yourself. I do not.
Sorry.
The mediation is sorry. I guess ଦେବେନି. ମୁଁ
ଦବା ଲୋକ ତ ରାଜି ଅଛି ଆପଣ କାହିଁକି ନବା problem?
ଗୋଟେ time limit set କରିଦିଅନ୍ତୁ to solve the problem.
My lord, fact was my lord.
Let us be practical.
No, my lord, fact was what a job.
Suppose I'll give time limit. He is not capable of paying. Then that time limit has no meaning. He'll come and say sorry. Finish. Again hearing. Let us be practical. He should be capable also paying, na? Agar if he is not at all capable, then what is use of this timing? He'll come and tell sorry, and again hearing will start. So try there in the mediation. You never know. He may give in one go, or I'll keep it after 20 days or about a month. You try your luck. Then we'll hear. Think over. Otherwise, I'll hear it right now. I have no issue.
Let it be in mediation.
That's a good idea because see, you never know. Many a time, what happens is he may give the money and may give. Yes. See, this is again a company. AC Narayan was considered in this case.
Yes, ma'am.
Para 26 is creating problem for you.
Para 17, say 26 and anyway, that becomes redundant now.
This petition is arising out of a dispute under 138 NI Act. The petitioner has challenged the order dated 13/1/2022, whereby the land trial court has taken cognizance of offence under section 138 NI Act. The petitioner fairly submits that he would settle the dispute if opportunity is given to him. The counsel for the respondent, though reluctantly, but agrees to try for mediation. Hence, the present matter is referred to Odisha High Court Mediation Center. Awaiting the mediation report. The matter is adjourned to 29th of this month, February. By that time, keep it open.
Yes.
Keep it open your mind. You
Let's
don't tell your client that you have a good case or you have a bad case, so that they will settling.
Better they get the money immediately. That is better.
That's
Small
the whole
amount is
idea.
better. Also.
That's the whole idea.
Yes.
110 here, 175. The total due. 110 he has already given. About 43, 45, 44 lakhs is there. He may fix installment. You are a businessman. You are a hotelier, businessman. Today you are getting money is more important, or you keep on fighting and after getting 10 years.
Obliged.
Get the money, use it. Okay. Yes.
61. So interim compensation they them the take care boys. It should have financially situation take kharab was we are running after that. Bars are closed. We are running a bar there and it's closed now. So that we are in a very big loss.
You must be drinking more than the customers. Yes. Try within 1 month, nothing will happen.
Yes, yes.
You may get some money, then
Yes.
yes.
Much.
Well, item 61, Mr. S.C. Mahapatra is appearing for the petitioner, but he has some difficulty.
Last date also, my lord, can have plans to out of sick. Last date also, the sick time. This is a case.
I can see the interim order.
My lord.
That's the problem. I don't give interim order in 482. Once you give in the interim order, this will happen. Sometimes requisites are not filed, sometimes he is not present, sometimes this happens.
My lord, kindly, hence I pray, my lord, kindly vacate the interim order so that matter can be heard.
What is this case?
My lord, this is a case in which cognizance taken for commission offence under section 302.
302.
My lord.
Okay. In 302 matter if you stall the trial.
Well, it's last chance. Well, it's any date, well, it's last chance. Well, it's
My lord, unless the
cognizance order was challenged. Huh?
Yes, my lord.
This is a complaint case.
My lord, initially the FIR was registered for commission offence under section 302 and 120B. The matter was investigated by crime branch. It is a case of burning. The officer, SCF, he was died by burning. Crime branch investigated into matter and submitted charge sheet under section 304A accident.
Okay.
95%.
Then you file protest petition.
Protest petition, my lord.
And the protest petition now 302 cognizance. He challenged that.
My lord.
Okay.
The wife and her paramar are the accused person, my lord.
May I please before you, my lordship?
The learned counsel for the petition.
May I please before you, my lordship?
Huh?
May I please before you, my lordship?
Yes.
On behalf of the present petitioner, my learned senior, Mr. Vishnu Prasad Prajan, is busy in the chief court. So kindly pass over the matter.
I think you are in some other matter.
there are two petitioners.
Two petitioners are there.
He's appearing from one of the petitioners. I am for the other petitioner.
I think now time has come to vacate the interim order. Now,
Well, it's last chance. Well, it's any other date.
Number of time, my lord, can have
there is only one. There are two petitions.
Yes, my lord.
The last and final opportunity. I'll put it on
day after tomorrow, my lord.
7th or 8th. Which date? 7th. The petitioners in both the cases, petitioner in both the cases are seeking time, seeking adjournment on the ground that their leader is the counsel for the petitioners seeks adjournment on the ground that their leader is not present today. The counsel for the opposite party number 2 opposes the prayer and submits that interim order. The petitioners are enjoying interim order and has been employing different tactics to prolong this matter. Taking into consideration the aforementioned facts, the matter is adjourned to 7th February. It is made clear that no further adjournment will be made.
Well, the interim order to continue.
Oh, all play is only for that.
To
continue till next date appearing.
Deeply obliged. Yes. That's deeply obliged.
Obliged, my lord. 64.
My lord, it may be taken off 1 week after.
Why you argue?
Well, my senior will argue and due
What
to
is this
medical
matter is about? Cognizance order.
whole criminal proceeding question.
What is the offense?
SCST Act is involved, my lord. Offense is
What is the offense?
294, 506, 34 and SCST Act section 3 of SCST Act.
Okay. Charge sheet. Where is
Charge sheet has already been filed.
Where is that?
I have already annexed on page.
Have you filed charge sheet here?
Sorry, my lord.
Yes, it is there.
It's
70
here.
page
I have
70.
already.
You are for which accused? Accused Bhavani Shankar Das,
Bhavani Shankar Das.
Pritham Kumar Sahu. Notice
Madam.
has been issued.
Yes, my lord.
Who is appearing for opposite party number 2?
I'm not sure.
Notice.
Notice has already been delivered.
Sufficient notice. You have to serve opposite party number 2. Note by the order dated order
As per noting, it has already been served.
by order dated 6/12/2023, notice to opposite party number 2 was issued.
My lord, as per the noting,
Delivered.
as per the noting, it has already been delivered.
Okay. Then simply adjourn. Chalo.
My lord, interim order to continue
There is an interim order.
Yes,
Short
my
date.
lord. On 6/12.
Short date. Interim order.
19th. Okay.
Yes.
65.
65.
My lord, in this case, my lord was pleased to issue notice to the opposite party. Here, what has happened, my lord? I filed a 138 NIA case, my lord. During the pendency of case, in the 2018, the opposite party filed a case if lodged an FIR. After registration of FIR, investigation was made. It was found it's a false case. Then it was dropped, my lord, on the ground of mistake of fact. Then, my lord, President opposite will file another petition complaint case. In that case, learned court below to cognizance, and I have also got an order from this honorable court to decide my application for. I'm sorry, my lord, 138 NI Act.
Wait, while take
No, my lord.
1 minute. Wait. Next matter.
66.
66. Yes.
My lord, I am for the opposite party. Yesterday, I have filed a Bakladhanama. Can we?
Mr. Chand is appearing for petitioner.
My friend is appearing for the opposite party. For some note.
Can the matter may put up after 4 weeks?
No,
I have not received the relevant documents.
All right.
Only I have received the
One
Bakladhanama.
act only one thing has to decide because of the fact that the consent check has been issued by the trust, whether it will the trust members or other person has not been added to the party. In view of the appeals court judgment, the cognizance will go. But whatever will be done, it will be attributed by the son of court. My friend is seeking.
What is the check amount?
Check amount 5 lakhs, 5-6 lakhs.
Why don't you give?
No, cognizance will go, madam. Cognizance will go definitely.
No, that is the reason I am saying pay the money. Trust money. Pay, finish up. Let us. I'll fix installment.
No, as my friend is seeking for time, I will give.
The time I'll give, but you think over it, pay and finish up. Cognizance order will go, then they file suit. Which is in limitation or not?
Suit.
The limitation theo 37 suit.
It will help 5 years also. Technically,
37 suit.
In such a case, now in view of that 143, the court is also stringent and imposing that the preliminary stage you have to pay and also the cases will dispose of within a short span of time. So only in such a case, only if technicality is there, that is the only consideration. And we are like.
But see, ideally, I tell you, if the cognizance order you are challenging, the 143 is pre-cognizance.
No, yes, of course.
Then 143 have you complied?
No, not complied. But things remain valid. When matter is adjudicated regarding the cognizance, and if I as likely pointed out in the particular previous case, if I somehow found that cognizance is valid in law, then why 143?
No, no. At the time of pleading guilty.
Yes.
So it is a pre-cognizance
Yes,
stage.
yes, my lord, what we
So 143 compliance has to be
No,
done.
that has to be
That young boy could not.
No, my humble submission, but that will be attributed by the concerned court below, my lord. And this honorable court, while deciding a matter on the cognizance, if this honorable court found that there is material, then the court will interfere. If the honorable court will interfere, then the cognizance will go, everything will go, my lord.
No, by next date of hearing, he will move an application on 143. Okay, adjourn it.
4 weeks after.
4 weeks.
Interim order will continue.
Yes. So, yes. 65.
Well, here actually main intention behind this complaint case, subsequent complaint case to frustrate my 138 NIA. This is of the year 2017. And there, my lord, cognizance has been taken. And that is also, I have challenged entire proceeding before your lordship. Other day, your lordship was pleased to call that other side because the money involved 3 lakhs rupees. Whether he will settle the matter, or the matter is there or not. That is why your lordship was pleased to issue notice. But my case is very clear because had it been the case prior to my 138 NIA case, the things could have been something different. Prima facie case has been made out because the check was lost, FIR was registered, and thereafter I have filed a 138 NIA case which can be adjudicated before appropriate forum, my lord. Here what has happened? I filed a case. I have a genuine claim. He has committed me to refund the money. When I check NCAS check, twice it was bounced. Thereafter, I filed a 138 NIA case, my lord. Then what he did, FIR, he lost an FIR in the year 2018.
You have stolen the check.
Yes. And that one was investigated. After investigation, it was found that that is a false case. Thereafter, my lord, he filed a complaint case in the year 2018. Once it's in our 11 of 2018. Here, on learned court below, to cognizance about the matter under 379 IPC. In the case of what has happened, my lord, my case, if your lordship today will direct that, let my application will be considered, decide on its own merit, that is different proceeding, this is different proceeding. If tomorrow I will be convicted on the basis of which, that will be, my lord, complicity will be there. Definitely, I cannot deny the same. Because once tomorrow it will be found that I have stolen the proper check and I filed this case. This can also be decided before the learned court below at the time of whether the check was given or it was not given. If it has been given, for what purpose, whether there is any debt or not.
By interfering in one case will have an impact on the other case. That's the problem.
Yes, that is the problem for which my humble submission, my lord, if any material will show before lordship.
Your complaint is his defense, his complaint is your defense.
But kindly appreciate, my case is here. I have filed, my case is very clear because I filed 2017, I filed the complaint case. Thereafter, first in that case, he come up with the grievance. My check was stolen, and you lost an FIR. And that FIR was also after thorough investigation, it was closed. Then you are filing another complaint case by way of protest, and in that case, cognizance has been taken. Now my case is now frustrated, my lord. It cannot be decided now. But if my lord kindly appreciate, my lord has much
this
better.
Is again in the protest petition.
Yes.
What is the service position? Written sufficient. I was thinking that once he comes, then
My lord, if your lordship will be pleased, then I will take again also fresh steps. I will file and I will take notice
take
on.
Dasti and try to serve.
Dasti will be little bit costly because it's a place where it is Uddala. I did it. Uddala, my lord, with the calculation will be here 2 and 4 3 times. Suppose from Cuttack to Uddala is 500 rupees, 2 and 4. It will multiply 3 as 1,500 rupees.
But Dasti generally you collect it and you serve yourself and file a affidavit of service.
My lord, here, my lord, we have to deposit. It will be assessed by the office. What will be the expenditure? One of the staff of this court will go.
Then take first step.
First step I'm taking because the opportunity should be given. Otherwise, tomorrow you will come up.
Because my idea was to finish all the things. That's the idea of issuing notice.
Yes, my lord.
Amount is only 3 lakhs.
3 lakhs, my lord.
We'll fix some installment. He'll give and
It will be, yes, my lord. That will be done also. That is your, my lord.
All the cases will.
Yeah, entire thing will go.
So let him take first step. Let him take first step. Returnable within 2 weeks.
4 weeks normal. Then the hospital nahi that is because
8 ko lagi fayda nahi na.
Yes, ma'am.
Jaldi hila jaldi.
Yes, ma'am.
Huh?
Filed.
Filed. Why are you telling slow?
Yes, ma'am.
Who has filed? Satyanarayana Behera has filed. Who is
The cause list না দেখে বলে বলতে আসি না।
Basant Kumar Das, Sangram Kumar Das? Enter the name and put it next week sometime. Next week. The opposite party number 2, on behalf of opposite party number 2, power about the Vakaratnama has been filed by one Basant Kumar Das and Sangram Kumar Das NDC. Since their name is not reflecting the cause list. Cause list. Name of Mr. Mr. Das, Basant Kumar Das and Sangram Kumar Das, we will reflect on the list and list it on next week. Huh? Alright, give service, the 19.
Yes, my lord, I have, may I praise small prayer I have. Cognizance has taken not Leonard Court below is proceeding with the case, my lord, that 1379 case, that offense which is against me, my lord. I have filed a petition for stay of further proceeding in GR case no 50 of 2018, my lord. Be meeting with Leonard SDJ Mudrawala, my lord.
When is the date?
Pardon, ma'am?
When is the next date?
Next date, my only anxiety, if the other day, next day he will come and take time, that is the whole problem.
My anxiety is once I give stay, you will take the time.
No, my lord.
That is what is the real practice. So I don't give 482 stay. I'll decide it. Finish.
My liberal adjournment may be given that, maybe. And that is not.
You tell me the date. If trial court date is there, before that I'll keep it. Yes. You must know.
19th form also. Well, I'll let you.
Otherwise,
205 petition can be filed there.
You can file it. You can file it. Otherwise, if you tell me the date so that I'll prepone it. You tell me date. Trial court date also you don't know.
Yes.
Then that is your problem now. 19. You should have come with ready with.
I am sorry, my excellent.
Anyway, 19. I don't think nothing will happen.
Yes, my lord. 19. Yes. Oblige, my lord.
59. No. Yes, 59. 59.
Lordship, here what happened? My request for lordship is lordship is under section 482. We have the inherent jurisdiction to secure the ends of justice, lordship. So far, from the bare.
See, I tell you, the fourth paragraph reading. Having regard to the gravity of offence, materials available, prima facie against the petitioner, I am not inclined to entertain the application.
Yes, that's
the coordinate bench says that prima facie evidence is there. And trial court also have done the same thing, taken cognizance. Today, suppose I'll give you relief, then I am sitting appeal over this. What do you want now? After this?
My lordship, by inheriting the 482 jurisdiction, lordship can direct ready to and surrender and go on bail.
Sorry.
It's ready and willing to surrender. Go and bail, your lordship. So far, present person having no criminal antecedents.
First sentence is correct. Next. First sentence I accept.
It's quite an lordship.
So better that you do whatever. I am simply.
No, that's it.
I am allowing you to withdraw. Okay.
That's it.
Land counsel for the petitioner submits that he would surrender before the court below and seek appropriate remedy available to him under law. Therefore, he seeks to withdraw this petition. Accordingly, the petition is dismissed as withdrawn. Go and appear.
Withdrawn, lordship, can I mention this?
Withdrawn
this. Lordship, but here what happened? This case is squarely covered by this honorable court, Supreme Appeals Court judgment, also honorable own High Court judgment, lordship. And from bare perusal, so far 306.
Today we are in cognizance stage. You can take bail and argue and charge. So
306 is
argue and charge, you may be discharged also.
So far bail part is concerned, I am
you could not convince two courts. Now you are coming under 482. Anyway, now 15? 50. Okay.
Petitioner and the informant belongs to same village Miller, challenging the initiation of a criminal proceeding. Under section 376, 506 and 450 of
Informant is
informant has already appeared, my lord. In the meantime,
Tripura.
the victim has already married and leading happy conjugal life, and the dispute
Married
has
with
been
whom?
settled, my
Married
lord.
with the petitioner.
My lord, I am
Married with the petitioner or someone else?
I am for the petitioner and
Opposite party number 2 married with whom?
Informant. I am appearing by the informant.
I am asking something else, sir. You are informant, opposite party number 2.
Two,
That
madam.
I understand.
yes, madam.
Now he says that you are married with the petitioner or someone else.
She has already married.
Para 4 I have written.
She has married to an Tarini Barik of village Telbahali.
That's what I am asking, whether you married with the petitioner or someone else.
Someone
that's
else. Well, I have filed the affidavit, my lord. She has filed.
376.
Yes, my lord.
Charge sheet is filed.
Charge sheet not filed, my lord. The case since the case is lingering since 2018, my lord.
She is the informant.
She is the informant.
Where is she? Informant.
No, I am appearing.
Well, where is she? Has to come.
No, she has not come. A date may kindly fix her.
ଆପଣ ଚାର୍ଜ ସିଟ୍ ଦେଖିଲେ ପୋଜିସନ ଟା
This proceeding against the informant will be initiated.
Okay.
It's not to meet the ends of justice. This purpose will not serve. You married to someone else and you compromise with this man and you file these criminal cases. And it's not a cases individual case. It's a case against the society. It's a case 376. Whom you are going to compromise? If you are married to the petitioner, leading happy conjugal lives, then only the 480 jurisdiction can be exercised, taking into consider their bright future. So now you married to another person, and you come forward to compromise.
That's there. You are absolutely correct. But the problem is that there are twofold. One is suppose we will force her to come trial. She will come and become hostile. And if the
that part is also absolutely right.
That is the reason 482 court takes a view. Okay, unnecessary. Why to put someone into trouble trial if the end result we know. To meet the ends of justice, a trial in futility may be curtailed justice.
There are 2 times judgments also there, my lord.
There are
some cases, my lord, the honorable court. When it became GR case, my lord, state is
state is because it's the offense against the society. It's not small offense.
They are also passing the proceeding.
Not small offenses. So therefore, both the things are possible. But
both.
Let us see. Let her come.
Yes, well.
Let her come. Bring both of them and we'll fix it on. Just fix it up on 13th, 12th or 13th. Oh, they will also be
13th, my lord.
15th. 15th, 16th, what?
15th, my lord, 15th.
15th. I'm to that. Let's see.
Thank you.